Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. Pursuant to notice, I now call up H.R. 2214, the National Origin-Based Anti-Discrimination for Non-Immigrants Ban, or the Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2214, to transfer and limit executive branch authority to suspend or restrict the entry of a class of aliens.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today we consider H.R. 2214, the National Origin-Based Anti-Discrimination for Non-Immigrants Act, or No Ban Act. With this markup, the House Judiciary Committee takes an important step towards reining in executive overreach, defending Congress's role in setting our nation's immigration laws, and righting one of the original sins of the Trump administration, the Muslim ban. Last September, this committee joined forces with the House Foreign Affairs Committee to conduct oversight on the implementation of the ban in its various iterations. During our joint hearing, we explored the chaotic rollout of the ban, the ongoing problems with its implementation, and its heartbreaking effects, including prolonged family separation. A 2019 Cato Institute analysis found that the ban has prevented more than 9,000 family members of U.S. citizens from entering the country, including more than 5,500 children. Inflicting this trauma on thousands of children and families has not made us any safer. In fact, it has weakened our standing in the world, and it runs contrary to our country's moral and philosophical foundations. And with the President's recent announcement that he is expanding the ban to include 6 additional countries, he has doubled down on this immoral and disastrous policy. The United States has always been and must continue to be a place that welcomes and embraces people of all religions and nationalities. But as a result of the Muslim ban, our country's reputation as a beacon of hope, tolerance, and inclusion for those fleeing persecution, reuniting with their families, or simply seeking a better life has been forever tarnished. Unfortunately, in 2018, after much litigation and many court injunctions, the Supreme Court upheld the third version of the ban, Presidential Proclamation 9645. The court's decision was not just a disappointing affirmation of the ban, it also helped enable President Trump's radical rewriting of the immigration laws through a broad reading of Section 212F of the Immigration and Nationality Act and a fundamental misreading of the relationship between Section 212, which governs admissibility, and Section 202, which governs the issuance of immigrant visas. Section 212F authorizes the President to suspend the entry of all aliens or any class of aliens when the President finds that such entry would be detrimental to the interests of the United States. But President Trump has stretched it far beyond Congress' intent and historical norms to devastating effect. It was intended to give the President significant discretion to quickly deal with emergent issues involving national security, public safety, or international stability. It was intended to give him flexibility. It was not intended to provide carte blanche authority to rewrite immigration provisions with which the President might disagree. From 1952, when this provision was enacted, until January 2017, presidents of both parties honored this provision by invoking Section 212F only in targeted situations to exclude well-defined groups of individuals for very specific reasons. Examples of prior uses include executive orders excluding serious human rights violators, North Korean officials, and individuals seeking to overthrow governments. But this administration has used Section 212F in ways that were never intended. The President first invoked the provision to deliver on his campaign promise to ban Muslims from the United States, a shameful promise based on stoking racial division and fear. Emboldened by the Supreme Court's decision, he has gone on to invoke Section 212F to effectively rewrite whole sections of the INA in blatant disregard of the separation of powers. For example, the President invoked Section 212F to deny asylum to persons who cross the southern border between ports of entry. But the Immigration and Nationality Act expressly provides asylum eligibility to any individual who arrives in the United States, quote, whether or not as a designated port of arrival, close quote. Section 212F simply does not provide the President the authority to rewrite the law when he disagrees with it. This should not be a partisan issue. Members on both sides of the aisle should agree that no president Republican, Democrat, or otherwise, should be permitted to usurp Congress' constitutional role in legislating. The separation of powers enshrined in our Constitution is sacred to our democratic society and must be protected. H.R. 2214 will stop this executive overreach by amending Section 212F to ensure it is used in a manner consistent with its intended purpose and historical norms. It will also explicitly repeal all 3 iterations of the Muslim ban to ensure that this disgrace is repealed and that we live up to our nation's founding ideals. I would like to thank the bill's sponsor, my friend and colleague, Representative Chu, for her leadership and steadfast commitment to this issue. The No Ban Act will uphold our values and defend the rule of law. I urge all of my colleagues in this committee to support this important legislation. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And once again, the President, we're discussing here, has taken a decisive action to help ensure safety and security of our country. And once again, our Democratic colleagues are so focused on stopping him that they're overlooking policy and other things to block a presidential action, even taking presidential authority away, even in light of, as the chairman said, previous attempts here, and especially in dealing in this section, have been upheld in the court. It is interesting to say that there's a discussion of not wanting this president to deal in immigration in the ways that he has, but there was not a lot of discussion from my colleagues when the former president, President Obama, did the DACA ban without any consultation with Congress and did it in a DACA bill and said, this is the way we're going to do it, and I'll just do it as I see fit with my pen and my phone. So here we are again reacting, and my concern is Mr. Chairman, as we go forward, and I'll talk about this bill, but I would love to have more in-depth discussions as we have had, and I know you, Mr. Chairman, Chair Lady Lofgren, and we've had on immigration issues. There's a lot we can be doing if we could have hearings and get to real issues in which we could find, bipartisan agreement instead of just being reactionary to everything that happens that we don't like from my Democrat colleagues don't like about this president. But let's deal with this bill. The Department of Homeland Security has identified several types of information that it needs in order to make a reliable decision regarding the admissibility of foreign country nationals seeking entry into the U.S. These include things like, does the country report lost or stolen identity documents, including passports, to Interpol, or how often do they do so? Does the country share information about their known or suspected terrorists or about their criminals with us? Does this country issue modern electronic passports? Who wouldn't think that these were important things to know when determining whether or not to let a foreign national into our country? Apparently, through this bill, my Democratic colleagues, instead of expressing appreciation for what the President has been able to accomplish with regard to security, my colleagues have attempted to and decided to mark up H.R. 2214, the No Ban Act, which effectively eviscerates the ability of the administration to take quick and decisive action to protect our homeland when concerns arise. Until the President signed the first travel executive order in January of 2017, very few had even heard of the Immigration and Nationality Act Section 212F authority. This act provides the President broad latitude to impose restrictions on the entry of aliens or classes of aliens to the United States, which such entry would be detrimental to the interest of the United States. But I remind everyone here, it has been used successfully by Presidents Ronald Reagan, Barack Obama, and others. Pursuant to travel executive order, the President required the Secretary of DHS and the Secretary of State, along with the Director of National Intelligence, to determine what countries fail to meet international standards of information sharing or identity management, or were at a high risk of terrorism or public safety concern, and to report their findings to him. Based on the assessment and the recommendations of the secretaries, the President placed travel restrictions on 7 countries. Pursuant to the continued review of the countries and an updated report last month, the President issued a proclamation imposing narrowly tailored travel restrictions on 6 additional countries: Burma, Kyrgyzstan, Nigeria, Sudan, and Tanzania. It is important to understand that such restrictions are not permanent. When a country comes into compliance with the information sharing and other requirements, they can be removed from the list of restricted countries. That happened in Chad in 2018, and press reports have already noted that the government of Nigeria is working to come into compliance. There is no doubt that the President's use of 212F authority has helped improve our security in the vetting of foreign nationals seeking entry into the U.S. As the DHS Assistant Secretary for Threat Prevention and Security Policy testified last September, one country reinstituted a dormant program to help identify convicted criminals. 3 countries have adopted a more secure e-passport. 2 countries obtained access to Interpol databases for the first time, and 8 countries began reporting lost and stolen passports to Interpol for the first time or improved the regularity of that reporting. These are not insignificant improvements to the world's security. H.R. 22414 would take 212F authority from the President and give it to a subordinate. Under this bill, only the Secretary of State can determine that the entry of aliens is a threat to the U.S. This is problematic in instances where other cabinet officials should be involved. The bill is a lawyer's dream, since it also does this. It interjects undefined and broad terms like least restrictive means and the notion of harm that are ripe for litigation, especially considering the bill's expansive judicial review provision and explicit class action allowance. This is a bill, especially with terms like this, should then never come out of this committee. H.R. 2214 also contains onerous reporting requirements, consultation with Congress before the President can act, and Federal Register publication of information about the action taken and the circumstances necessitating the action. Of course, it makes no sense for the U.S. government to broadcast to the public the deficiency they have identified, since those would be exploited by bad actors seeking to harm those foreign countries or the U.S. But perhaps the most incredibly amazing provision is Section 4. Which not only terminates the travel executive orders in place, but incredibly ceases all action taken pursuant to any proclamation or executive order terminated by the bill. This means that the information sharing on terrorists, criminals, and other security threats that is derived between the U.S. and other countries with travel restrictions would stop. How does that even sound like solid policy? It makes no sense whatsoever. This bill is just another more knee-jerk response by my colleagues who do not like this president and have made it very clear over the last 12 to 13 months. It would undermine the safety and security of Americans, and so with that, I would urge my colleagues to oppose H.R. 2214, and I yield back the balance of my time.
I now recognize the chair of the Subcommittee on Immigration and Citizenship, the gentlelady from California, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. As you mentioned in your opening statement, we have spent a great deal of time examining the impetus and the aftermath of the administration's Muslim ban, and I wish that today's markup of the National Origin-Based Anti-Discrimination for Non-Immigrants Act, or the No Ban Act, wasn't necessary, but unfortunately, it's more important than ever. As a result of the administration's most recent expansion of the ban in the form of Presidential Proclamation 9983 and the President's attempts to rewrite our immigration laws, immediate steps must be taken to rein in repeated abuses of executive authority. Now, as a candidate for president, Donald Trump promised to ban all Muslims from entering the United States. He suggested, without any evidence, that it would somehow make our country safer, and immediately upon entering office, he tried to deliver politically on that promise, only to have his first executive order stopped by the courts as unlawful. As we discussed in the joint hearing with the Foreign Affairs Committee in September, it took the president 10 months, 3 attempts, and the inclusion of what looks to be a bogus waiver process to persuade a majority of the Supreme Court that the ban was not inspired by religious animus. The administration claims the ban is necessary to keep our country safe from terrorist threats. Yet, a bipartisan coalition of former national security officials concluded otherwise. According to Madeleine Albright, General Michael Hayden, former Senator Richard Lugar, and many others, quote, overwhelming evidence demonstrates that the ban failed to advance national security and foreign policy interests, and in fact, damages those interests. Now, in addition to invalidating President Trump's multiple iterations of the Muslim ban, this bill prohibits executive overreach in immigration law more generally. The bill amends Section 212F of the Immigration and Nationality Act to realign that section with its intended purpose and historical norms. What this administration doing is very much an outlier to how the section has been used historically. Before January of 2017, both Republican and Democratic presidents had invoked the section, as mentioned by the chairman, in targeted situations to exclude well-defined groups of individuals. In contrast, President Trump invoked 212F sweepingly and without really any adequate justification. He cited, as the chairman has mentioned, 212F to circumvent the clear statutory requirements related to asylum. The litigation on that is not yet concluded. Some have suggested that we should do something about the asylum situation, and my thought has been, what, should we reenact the Immigration and Nationality Act? Because it's very clear that what the president has done violates the statute. I believe that the president has misused Section 212F when it comes to asylees seeking to make their claim. And you know what's really important is that the Congress writes the laws, including the immigration laws, not the executive branch. That violates the Constitution. The power to write the law is ours, not the president's. And because of this repeated overreach, this bill is necessary. The bill is not targeted to President Trump. It's targeted to the executive branch, saying you cannot misuse the authority. You do not have the authority to write the immigration laws of the United States. And I would like to address the issue of DACA, which is on its way to the Supreme Court. There was substantial legal work done on that. I participated in it. The research indicating that there was firm basis in law, as well as ample historical precedent. The authority, the parole authority was used extensively by President Reagan and President Ford and others, by Eisenhower. Some have objected to that. We will get a ruling from the court and see whether the legal research at that time holds up to scrutiny by the Supreme Court. But it was not done without a basis in law. It was not done without looking at historical precedents. This, in contrast, is just a complete rewrite of the law at odds with the clear language of the statute and all of the precedents that preceded both by Republican and Democratic presidents. I want to thank our colleague, Representative Judy Chu, for her leadership and steadfast commitment to this issue. Her efforts led to the introduction of this legislation, and I hope that we are able to pass this bill out of committee today. And I yield back, Mr. Chairman.
I thank the gentlelady. I now recognize the ranking member of the Immigration Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chairman. Sadly, the chairman of this committee and the chair of the Immigration Subcommittee falsely characterized the president's policy limiting travel from a small number of countries to the United States as a Muslim ban. The truth is that the president's policy is limited to 7 countries that are state sponsors of terror, significantly compromised by terrorist organizations, or in an active conflict zone. All 7 of these countries are currently subject to a State Department Level 4 travel advisory warning U.S. citizens not to travel to these countries. Iran is a state sponsor of terrorism. The U.S. has no diplomatic or consular relations with Iran and hasn't since 1979. Libya is a state sponsor of terrorism. The Obama administration suspended U.S. embassy operations in Tripoli in 2014, and the FAA prohibits U.S. commercial aviation within the Libyan airspace. North Korea is a state sponsor of terror. We have no diplomatic or consular relations with the Hermit Kingdom, and the FAA has adopted special regulations related to aviation near North Korea. And by the way, North Korea has less than 1% Muslim population. Somalia is largely controlled by al-Qaeda affiliate al-Shabaab. We have no permanent consular presence in Somalia. Syria is war-torn. The Obama administration suspended U.S. embassy operations in Syria 8 years ago. The Czech Republic currently handles limited consular functions for the United States. Venezuela is rightly considered a conflict zone. The U.S. has suspended all consular services in Venezuela, and the CDC has also issued a travel warning related to Venezuela due to the breakdown of medical infrastructure. Yemen is also subject to terrorism and civil unrest. The Obama administration suspended embassy operations in 2015. There are 50 predominantly Muslim countries around the world, and 45 are not subject to restriction. Afghanistan is not, Turkey is not, Jordan, Saudi Arabia, Indonesia, and Egypt are not. What is this policy really about? Making sure we can sufficiently verify every individual who wants to enter the U.S. is not a criminal or terrorist. The primary duty of government is to protect its citizens. The simple truth is that we cannot properly vet people coming from a country where the government has collapsed or we have no consular presence. For nearly 40 years, presidents have relied on existing legal authority to suspend entry into the U.S. in times of national emergency or to prevent a crisis. The bill we are about to consider, the No Ban Act, would completely upend this authority, known as 212F. There are several problems with this bill. The first problem is constitutionality. This bill states that the president can only act if the Secretary of State and Secretary of Homeland Security consult with each other and make a finding. This bill cuts the president out of the process and subordinates his Article II authority to the findings of members of his cabinet. The second problem with this bill is that it appears to preclude the use of 212F authority in response to a public health crisis. Why is that? No ban allows the president to act only when there is a security or public safety concern or in the other limited circumstances. It provides no express authority to the president to act in the face of a public health crisis. Some might argue that the public health issue, like a pandemic, is a public safety issue. In response, I would note that government distinguishes between the two based on the answer to this question: who leads? Who leads during a public health crisis? It is typically Health and Human Services, the Centers for Disease Control and Prevention, the Surgeon General, health departments, and medical professionals. No ban excludes these officials from the consultation process. Less than 2 weeks ago, President Trump relied on 212F authority when he announced travel restrictions from Wuhan, China in response to the coronavirus. Now, Democrats are pushing a bill that strips the president of his authority to limit who he can consult with and to deny public health officials a seat at the table. That's reckless. I urge my colleagues to oppose the No Ban Act, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2214, offered by Mr. Nadler.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I now recognize myself to explain the amendment. Many of the changes in this amendment are either technical in nature or are necessary to clarify the intent of the underlying legislation. For example, the congressional consultation notification sections of the bill were consolidated into a single paragraph, and clarifications were made to the reporting requirements. In addition to these technical fixes, the amendment makes a few substantive changes. First, the amendment to the non-discrimination provision in Section 202A1A of the Immigration and Nationality Act was altered to ensure that the INA's non-discrimination provisions clearly cover admission and parole into the United States. Second, the amendment to Section 212F was altered to more clearly outline the contours of the presidential authority to block the entry of aliens. These changes are intended to strike the right balance between giving the president flexible authority to address emerging and pressing issues and preventing the president from using his authority to effectively rewrite the immigration laws when he does not agree with them or want to follow them. Third, a rule of construction is included at the end of Section 212F to further clarify that the authority does not allow the President, the Secretary of State, or the Secretary of Homeland Security to act in a manner that is inconsistent with policy decisions expressed by Congress in the immigration laws. Fourth, changes were made to the reporting provisions to ensure full transparency when using the authority in Section 212F. Finally, conforming and readability changes were made throughout the bill to better clarify the bill's intent. All of the changes made in the amendment improve on a good bill, and I urge all of my colleagues to support the amendment. I now recognize the ranking member, the gentleman from Georgia, Mr. Collins, for any comments he may have on the amendment.
Thank you, Mr. Chairman, and I appreciate, there's nothing, different about the nature of the amendment substitute, but I do want to address, I think it was really interesting because we just spent a long time addressing a point that I made about DACA. Well, what's interesting about this, and Chairwoman Lofgren is an eloquent speaker, and I know she's trying to make this equivalency, but here's the deal. Congress wrote 212F. we never wrote the DACA program. And you can have all the kind of consultation and everything that you want about, that it was talked about and discussed in legal authorities and everything else, but we wrote the 212F, which is what this squarely falls under. And this interesting to me as well, though, is up until actually giving it, President Obama on multiple occasions made declarations and said, I'm not king. I can't do this just by myself. In respect to that notion, I can't just suspend deportations through executive order. That's not just the case. May 2011, just bypass Congress and change immigration law myself. That's not how democracy works. You may like the DACA bill, you may not like the DACA bill, but comparison of the two here in the use of 212F, and in that regard is not equivalency in my mind. And I appreciate the argument, but it's just not true. And I think one of the issues, it is amazing how we like part of 212F, and we're going to have an amendment about this in just a moment on what travel orders we didn't suspend in direction to national emergencies. And I'm looking forward to Mr. Biggs' amendment on that as we come up on the coronavirus, which is interestingly exempt from this bill. So with that, I yield back.
The gentleman yields back. Are there any amendments to the amendment in the nature of a substitute? Gentleman from Arizona.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
I reserve right to object.
Gentlelady reserves the right to object.
Amendment to the amendment in the nature of a substitute to H.R. 2214, offered by Mr. Biggs. Page 2, strike lines 9 through 10 and insert the following. If the President, after consultation with relevant cabinet members, determines based.
The gentleman is recognized for the purpose of explaining his amendment.
Thank you, Mr. Chairman. My amendment restores the presidential authority. The document, your amendment in the nature of substitute, subordinates the authority, Article 2 authority of the President to the Cabinet. This is contrary to Article 2 and the intention of the framers of our Constitution, who specifically rejected an oligarchical approach to the chief executive office of our government. Rather, they gave authority to the President with authority to nominate subordinate officers such as cabinet members. This bill actually turns the executive branch and presidential authority upside down. H.R. 2214 gives the authority to initiate a suspension of entry not to the President, but to the Secretary of State in consultation with the Secretary of Homeland Security. But it's the President in whom all executive power vests constitutionally, who should determine whether to suspend entry not just in consultation with State and Homeland, but with any relevant cabinet official. For example, President Trump recently issued a presidential proclamation suspending entry of certain individuals who were physically present in China during the prior 14 days. This was done in response to a novel coronavirus outbreak in China. But the President did not only consult with State or Homeland, but with the Centers for Disease Control and the Secretary of Health and Human Services. Under H.R. 2214, the President would not have been able to use 212F to protect us from the coronavirus. When President Obama issued Proclamation 8693 suspending entry of aliens subject to UN Security Council travel bans and International Emergency Economic Powers Act sanctions, he directed the Secretary of State to implement the proclamation in consultation with the Secretary of the Treasury. Under H.R. 2214, President Obama would not have been able to so act. Of course, State and Homeland Security are necessary entities when considering a suspension on entry, considering that State Department issues visas and Homeland Security determines admissibility of individuals presenting at ports of entry. But they alone are under-inclusive of the range of potential cabinet officials who would need to be consulted or even take the lead in an action to suspend entry. In a time of war, for instance, the Secretary of Defense would need to be consulted. In a time of disease outbreaks, such as the coronavirus, the Secretary of Health and Human Services would be consulted. What if the government is seeking to use a suspension on entry to sanction foreign nationals who harm U.S. financial interests abroad? Then Treasury would need to be consulted. And if there are national security implications, then the Office of the Director of National Intelligence would need to be consulted. These examples prove for themselves that the President should be the sole arbiter of 212F authority in consultation with other cabinet officials, not the other way around, and not limiting the authority only to the Secretary of State in consultation with the Secretary of Homeland Security. Do you really think that the President should be subordinate to the Secretary of State? My amendment returns the 212F authority to its rightful place, not in the hands of a subordinate cabinet official, but in the power of the President of the United States. The President, as the executive, whether you like him or don't, should have this authority to be able to respond nimbly to any number of threats our country might face, or as a tool to compel foreign actors to conform to behavior conducive to U.S. policy goals. I urge my colleagues to reconsider their unusual position and to vote for my amendment to ensure that 212F authority will be utilized to protect America in the future. And with that, Mr. Chairman, I yield to the distinguished ranking member, the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Big. I appreciate the gentleman's amendment because it exactly goes back here. It's amazing that your amendment actually strikes at the heart of this bill. It's about the president. It's not about the process. It's not about 212. It's not about a consultation with anybody else. It's about the president and taking the president out of this because they don't like the president's role. And it is interesting to me, like I said, this terminates many of these travel executive orders. It does not terminate this one on the coronavirus. So it's interesting that they can't, that's a bridge too far because they know the epidemic proportion of coronavirus right now, and we're not exempting it. But so if he's able to use it there, we're saying it's okay because that's a disease that we'll agree with, but they don't like it when it's security-based in reasons across our country. So I support your amendment. I think it's frankly, though this amendment highlights the problem that we've solved with this bill, it's not about fixing the problem, it's about getting at a president. And it's the only issue that we have here, because at the end of the day, the subordinate nature of the Secretary of State and others is that they are under the president. And any action they take would have to come under him, not their own. And I think that's the separation of powers issue, which is a tricky wicket in this one right here. So with that, I'll yield back to the gentleman from Arizona.
Thank you, reclaiming my time. And I would say that it is important if we consider the separation of powers, if we consider so many arguments have been made recently about separation of powers, so many arguments recently been made about the intention of the founders. The intention of the founders was not an oligarchical form of government in the executive branch. It was to have a president who had the authority of all of Article 2, and his cabinet officials are subordinate, and this turns it on its head, and I yield back. Thank you.
I recognize myself in opposition to the amendment. This is an amendment that does nothing. And with all the Sturm and Drang, all the discussion we've just heard, the amendment does nothing. The existing language says, if the Secretary of State, in consultation with the Secretary of Homeland Security, determines blah, blah, the amendment says if the President, after consultation with the relevant cabinet members, determines. Well, the President obviously can consult with relevant cabinet members. The Secretary of State is automatically subject to the President. This gives authority to the bill gives authority to the Secretary of State, but obviously if the President disagrees with the Secretary of State, he predominates. So the amendment makes no practical difference whatsoever, and is frankly a waste of time. I yield back.
Would the gentleman
I
yield?
yield to the gentlelady from California.
First, I'd like to withdraw my point of order.
Gentlelady withdraws her point of order.
And secondly, I would like to say that there's nothing in the act, just to be clear, that prevents the president from consulting with other cabinet members. It simply requires him to also consult with the Secretary of State and Department of Homeland Security. He can check with, the Commerce Department, whoever he thinks is relevant. He's free to do that, or she, in the future. I mean, this isn't about Trump. This is about the executive branch. And I agree that the amendment does not, it's a solution in search of a problem. And I yield back to the chairman.
Reclaiming my time, it's not only a solution in search of a problem, it's not a solution. It doesn't change the situation or the law in any way. I yield back.
I claim time.
I yield to the gentlelady.
Further yield, there's another section of the law that specifically empowers the Surgeon General, 42 U.S. Code 265, to suspend the entry of a person or property if by reason of the existence of any communicable disease in a foreign country, there's a serious danger of introduction of such disease into the United States. So, that's existing law. This does not preclude that, and I yield back to the chairman.
The gentlelady yields back.
I claim time.
Gentleman from Georgia.
Thank you, Mr. Chairman. It is amazing to me that the argument that I've just heard from the chairman and the chairman of the subcommittee basically eviscerated the whole bill. And it made it very clear on what's happening here. Because they said, well, he can talk to anybody. Then why put it in the bill? Then why put it in the bill that this is who you have to talk to when the chairman and the chairlady of the immigration subcommittee just said he can talk to anybody he wants to? It's very obvious why this is here. It's a usurp of power and a separation of powers. They want to get at the president. This is nothing more, nothing less. And it is funny that we went around this, and I acknowledge the fact that they did exempt this travel order on the coronavirus, because that would even be a step too far in getting at this president to endanger with the things going on with the coronavirus. But security seems to be okay if we want to deal with that. With that, I'll yield to Mr. Biggs.
Thank you, Mr. Rink. Mr. Collins, I appreciate that. Well, I agree with your point that it eviscerates the bill. If my amendment is unnecessary and superfluous, then the language that you have here is unnecessary and superfluous. But it really isn't, because the statutory construction, the way this is written, before the president may temporarily act, there are some conditions precedent, and that would be in line 8, subject to paragraph 2. So that's a reference to lines 23 forward. But if the Secretary of State, in consultation with the Secretary of Homeland Security, determines, and then the chairman said blah, 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 blah. Well, that's interesting, because the language here is quite specific. If those two individuals determine, based on specific credible facts, and then the additional conditions precedent are present, then and only then may the president temporarily act. I am baffled that the argument is blah, 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 blah. Statutory construction specifically imposes conditions precedent on the president. And those conditions precedent are having to be directed, if you will, by subordinate cabinet officials. That's the language you put in here. If you think that my amendment is superfluous, then really what you need to do is delete the whole paragraph, because what you're doing is you are flipping our Article 2 power in the Constitution granted to the President of the United States. You're giving it to subordinate officers and making their determinations the controlling factor on when, in line 16, the president may temporarily do the following acts. And so with that, I'm going to yield to, if anybody else wants time. Okay, I'm going to yield back to the gentleman.
The gentleman can yield back to an empty seat if he wishes.
Yeah, I'm yielding back to the empty seat.
The gentleman, having failed to yield to anyone else, does anyone else seek recognition of this amendment?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, based on the candidates that the Democrats have now for president, it is unlikely that anytime soon we will have a Democrat president. But the bill that you are offering, if it becomes law, will cause will restrict not only this president, and I understand from the last markup that we had in this committee in December that the other side doesn't like this president on a personal level, regardless of whether his actions have violated the Constitution or not. But you are now allowing the party who can't run caucuses in Iowa, who has to dismiss the host committee in Milwaukee, to someday elect a president, hopefully not in my lifetime, that will be bound by this ridiculous concept. It is as if the legislative director in all of your offices can decide how you vote. You can only vote a certain way if the legislative director in your office says, yes, I think that you can vote yes on this bill. Then you would be allowed to vote yes. The president can't act until the Secretary of State says that it is appropriate for the president to take certain action. That is absurd and unconstitutional, and something the Senate will never take up. So once again, you have decided to insult the presidency because of a man you don't like in that position. But this bill is illogical. I suppose the president could fire the Secretary of State if the president disagreed with the Secretary of State's findings and appoint an acting Secretary of State over something like this. But the idea that we are going to have a cabinet official with presidential power based on this bill, I find to be inconsistent with how not only our founders, but for over 200 years, we have interpreted the Constitution. I'd be glad to.
Thank you. I just want to express satisfaction that the gentleman with being able to agree with the gentleman that this bill is intended to apply not just to President Trump, but to any president, I'm sorry. But to any,
There's the Freudian slip.
but to any president. We believe that no president should have the authority that has been wrongfully exercised by President Trump, but no president should have the authority to ban religious groups. I yield back.
Well, reclaiming my time, I don't think, and I said, I think very clearly in my opening statement that this president has banned a religious group. He has banned individuals from coming to this country from 7 countries. 5 of those countries are predominantly Muslim. 45 countries that are predominantly Muslim have no travel restrictions on them because we're able to communicate with their government and find out information about individuals that are interested in coming to this country. So to again, you mentioned something in your opening statement that I frankly found insulting, and that is that this president shockingly was trying to divide our country or stoke racial fears or religious fears. That's not the case. The case is that this president is trying to protect Americans from folks that are coming to this country from countries that are unstable. And it is sad when this committee lowers itself to the point of throwing racial bombs at or religious, suggesting that this president is trying to discriminate against various religions. It is sad. And this bill, while it would apply to another president, is particularly aimed at this president and mischaracterizing the actions of this president. And with that, I yield back.
Mr. Chair.
Gentleman yields back. Gentleman from Arizona.
Yes, thank you, Mr. Chair. Thank you.
Stanton from Arizona. Mr. Stanton from Arizona.
Thank you very much, Mr. Chair. I move to strike the last word. I speak in opposition to the amendment and in favor of the underlying bill. President Trump's Muslim ban 3.0 has caused immense damage to families seeking refuge in the United States. Our nation has always stood as a beacon of hope and opportunity, a leader in the free world. Unfortunately, over the past few years, those values have been tarnished by cruel policies that separate children from their parents, wives from their husbands, and siblings from one another. I'm encouraged to see the Judiciary Committee moving forward with H.R. 2214, the No Ban Act, to repeal the Muslim ban and the broad non-discrimination provision of the Immigration and Nationality Act to include religious-based discrimination. I'd like to share a couple stories today of my constituents who have been impacted by this cruel law. Ramez Al-Ghazuli married his wife, Esma, in 2015. The war in Syria caused Ramez to move to Mesa, Arizona, to study business administration and management at Mesa Community College, while his wife moved to Istanbul. Ramez began to create a life for himself in Arizona and started working for the state of Arizona by becoming a business analyst at the Arizona Department of Economic Security. Yet there was always one thing missing: his wife. Ramez was a legal permanent resident and petitioned for his wife to join him in Arizona. But in 2017, President Trump signed the executive order banning citizens from 7 Muslim-majority countries from traveling to the United States. Syria was one of those countries, and despite being eligible for a waiver, his wife, Esma, was denied a visa with no explanation. Ramez wrote to the State Department, Department of Homeland Security, members of Congress, even to the president himself, but nothing worked. It was not until Ramez went public and decided to share his story with the media that there was movement in the case. After 3 long years, Esma was finally granted a waiver and visa into the United States. Media attention shouldn't be the mechanism by which immigration cases move forward. Unfortunately, spouses haven't been the only families impacted. Nadifa Halan and her 5-year-old son arrived in Arizona in 2014 as refugees from Somalia. In 2016, she filed the appropriate paperwork to request her husband and 2 children to join her in the United States. But because of the Trump administration's Muslim ban, what used to take about 6.5 months to process can now take years and years. To this day, 3 years later, he is still waiting for a decision about his children. That's unacceptable. Her now 10-year-old son uses mobile apps to talk to his father and siblings. And Nadifo is watching or 2 other children grow up through Facebook pictures. Our nation should be building an immigration system that doesn't discriminate based on origin or religion. Families like Nadifo's should be considered at the heart of our immigration policies, not be left behind by them. Arbitrarily keeping families like these separated does not make our country safer. Instead, it causes undue hardship, stress, and trauma to families that have already experienced unconceivable circumstances and simply want to be together. I'm proud to be a co-sponsor of H.R. 2214 and hope to see the House consider the bill as soon as possible because hate should have no home here in the United States. I yield back.
Mr. Chair.
Gentleman yields back. Who else seeks recognition?
Right here.
For what
Mr.
purposes,
Chair.
gentlelady from Arizona seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. I agree with my fellow Arizonans on certain things, but certainly not on this. In fact, to me, it's just a bunch of rhetoric. When you call this a Muslim ban, that's totally disingenuous. It's just rhetoric for their side of the aisle, and to call it a cruel law. Well, then I ask my Democratic colleagues, including my Democratic colleague from Arizona, why didn't you complain about it when President Obama, I mean, in the original executive order 13769, the countries that were determined to be in that were actually identified by Congress and the Obama administration to be countries of particular concern for terrorism activity. And also the Supreme Court noted that the text says nothing about religion. And the policy covers, that policy before the extra countries were added, covers only 8% of the world's Muslim population. This has nothing to do with religion. This has to do with securing our country and securing our nation. So to continue to promote this divisive rhetoric is just, it's just not true. I mean, if it really was, as you call it, a Muslim ban, why wouldn't Indonesia be banned? I mean, they have a lot of Muslims. I mean, this is just inaccurate. You're just spreading this falsity, and I yield back my time. Oh, and I actually would like to yield the rest of my time to Mr. Biggs.
I thank the gentlelady.
When you have time.
I just want to point out a couple things that were wrong with our colleagues from Arizona, who I have great respect for and have worked with and known for many years. This was not, the original ban, plus the supplemental ban that was recently issued, has been characterized wrongfully as a Muslim ban. But I would just suggest to you that a fraction of the majority Muslim nations of the world were included in that ban. Number one. Number two, an example would be Indonesia. Indonesia has more Muslims in it than all of the other majority Muslim nations in the world combined. And yet we deal with them. Why do we? Why were those nations put on the ban? There are several reasons. First of all, they don't share information with the United States or Interpol about known or suspected terrorists or even their own domestic criminals. They don't share that with the U.S. or Interpol. We don't know who these folks are. They don't share information on lost or stolen identification documents, such as passports. Or when they do share them, they give them to us in a tranche, maybe once a year. That doesn't help us. They don't receive people who we've determined to have committed crimes that we would ordinarily deport. They won't receive them back. They don't share copies of official documents like their passports with us so we can develop a template of what is an actual bona fide passport or identification document. They don't give us access to electronic passports. There's a minority of countries in the world that do this. That is why the travel ban was instituted not only by this administration, but previous administrations that were trying to resolve these issues. With that, I will yield, if it's okay with the gentlelady from Arizona, to the gentleman from Colorado.
Thank you.
Ms. Lesko's time. The time belongs to the gentlelady from Arizona.
Thank you, Mr. Chairman. I yield my time to the representative from Colorado.
Gentleman is recognized.
Thank you, Mr. Chair. I was just going to ask Mr. Stanton a question, if I may, if he would be willing to respond. He indicated in his statement that there were 7 Muslim-majority countries that were under the travel restrictions from the President's executive order. If he would be so kind as to correct his statement and acknowledge that North Korea and Venezuela are not Muslim-majority countries, I would appreciate it.
Gentleman yields.
I was being advised by the question was being asked, but I think in sum, the 7 countries were in the original Muslim ban that was found to be unconstitutional. That's what I was referring to.
Oh, okay, so they aren't Muslim-majority countries?
I apologize.
I'm
What is the
asking you
question,
if-
sir? What is the question, sir?
Are the 7 countries that are listed currently in the travel restrictions by the President's executive order majority Muslim countries?
Yeah.
I'm sorry, what I was referring to in my
Gentlelady's time has expired. Who seeks recognition?
I do. Chairman,
Gentlelady from Texas.
Chairman, be happy to yield time to the chairman.
Thank you.
I move to strike the last word.
Last word is duly stricken, and I thank the gentlelady for yielding me time. I simply want to say that the question has arisen, the comment has been made that this isn't a Muslim ban, that various countries are on the list because of various different factors. How do we know? We know because the president, who is occasionally honest, told us so. The president got up and said, we will ban all Muslims from coming into this country until we figure out what the hell is going on, unquote. When he couldn't get away with that, the Supreme Court, then they started after the fact rationalizations such as what we're hearing today, and they finally narrowed it enough and got a gullible enough Supreme Court to uphold it on other grounds. But we know why they did it. He told us. And he is occasionally honest. I yield back. I yield to the gentlelady from... I yield to the... I
thank the
gentlelady.
Point of order, the chairman. Point of
I
order.
thank the chairman.
Mr. Chairman.
The gentlelady has the time.
I thank the chairman very much. Let me follow up, rise to support the manager's amendment and to thank Ms. Chu, Congresswoman Chu, for the astuteness of her legislation. But let me begin to go down memory lane and remind our friends that this president promised a total and complete shutdown of Muslims entering the United States. Now, I want to be very clear to my friend in Colorado. I have no reason to spend a lot of time disliking the personal individual who is President of the United States of America. None of us as members of Congress have time to do that because we have to do work on behalf of our constituents. What I do find challenging are the actions. And many of us who are raised by parents who said, your deeds and actions speak louder than your words. And so, even in the last 24 hours, when this commander-in-chief has taken to turning upside down a storied institution like the Department of Justice, having prosecutors walk away from the case they had worked on, ignoring and denigrating a jury that had listened to a case and convicted an individual, and having a prosecutor of integrity walk out of the Department of Justice. I can only go on words. And in the course of the words that resulted in deeds of this president, he has called these countries S-hole countries. He has indicated his disdain by saying that Nigerians will never go back to their huts once they have seen America. 81% of those targeted in the new travel ban are African, amounting to a ban on 1/4 of all Africans. My good friend from Colorado indicated, or one of the members indicated, so let me stand corrected, that the idea was that the travel ban is not offensive. The travel ban eliminates all manner of opportunities to come into the United States from these countries. I will admit that terrorism exists on the continents that these countries come from. I will admit that we are fighting Boko Haram, among others, in and on the continent of Africa. So are the countries. And I will say that it is not every single Sudanese. It is not every single Eritrean. It's not every single Nigerian. It's not every single Tanzania. The last place I went with President Obama before the end of his term was Tanzania, speaking to young entrepreneurs eager and excited about building the economy of the continent. How dare my colleagues say that this is not a pointed Muslim ban, for these countries are Muslim. But there's not one ban against Saudi Arabia, whose soldiers came to our soil when we opened the door to the idea of sharing our genius and the preciousness of our young soldiers, that they took the life of young soldiers on our soil, that we opened the door. I've yet to hear a report. I've yet to hear the president stand up and say, what a dastardly and horrible act. And if anyone was here for 9/11, they know it was the Saudis who took that tower down. And so I'm amazed that we could take these individuals, and what I would suggest to my colleagues, that they join us in the No Ban Act so that we can assess legitimately the criteria that those who would harm us can be blocked from coming into this country. I yield back.
Gentlelady yields back. Who seeks?
Mr. Chairman, I seek recognition.
Gentleman from Pennsylvania, for what purposes?
To strike the
For what
last word.
purposes the gentleman from Pennsylvania seek recognition?
To strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I yield to my good friend and ranking member, Doug Collins.
Thank you. I appreciate the gentleman yielding. Because what we have found today in the policy of discussing this bill, the chairman is occasionally honest. He decides to be occasionally honest when he wants to talk about a bill. He's occasionally honest when he's talking about the words of this bill. This is a bad road to go down. This is a problem. You can disagree about purposes, you can disagree about bills. But this committee, since last week when we ignored time limits, when we partially said, well, somebody gets more time than others and cut our members off, and now today we've let it go long enough. But we've admitted from the chairmanship that by showing even this amendment, that this is about the president. But this occasional honesty of the president comment, and now having your own parliamentarians say, oh, that's okay because it's within policy, so here's what we're going to do. Mr. Chairman, you're occasionally honest when you talk about the president. You're occasionally honest when you talk about your colleagues. Ms. Lofgren is occasionally honest when she talks about immigration.
Mr.
Let's
Chairman.
fool nobody here.
Mr. Chairman.
I'm not yielding.
No, I'm not asking to yield. I have a parliamentary inquiry.
Go for it.
The gentleman is not recognized. A parliamentary inquiry is not recognized while someone has the floor.
I have a point of order then.
The gentleman will state his point of order.
Is it within the rule? Isn't it a violation of the rule?
The gentleman will state his point of order.
Isn't it a violation of the rules of this committee when a member casts aspersions on other members of this committee by accusing other members of this committee of being dishonest? Isn't that a violation of the committee rule?
I don't think it is a violation of a committing rule to call someone
I would ask the parliamentarian.
to call someone occasionally.
I welcome a ruling on this one.
I do not think it is a violation of the committee rule or of any rule to call someone occasionally honest. I recognize that the president has been called never honest. I think he's occasionally honest. Many people think he's never honest, but I think it's fair comment.
Mr. Chairman, you have been accused of being dishonest.
Mr. Rest is all his time.
I have been accused of being dishonest. I take it from the source
You
from
were
which
just
it comes.
accused of being
Gentlemen,
dishonest.
I know that. I take it for the source from which it comes. The
still-
gentleman may proceed.
I appreciate it. My point is now made. This committee's got to be better. We can disagree on a lot of things. We can have some of the harshest disagreements in this committee, and that's what this committee's for. I've been on it for I'm starting my 8th year. We have been on both sides, both majority and minority. But Mr. Chairman, this has got to stop now. Let's stop it in January, in February. Let's stop it here. We can't, 5-minute rule exists because 5-minute rule protects all parties, not just the minority, not just the majority. We can't go right up to the line and say, and by innuendo and facto say, people are occasionally honest. I am not going to say that about you. I said it for a purpose because of the ruling that we've had in the discussion here. This needs to get back better. We can disagree with the president and say, I disagree with the president. I can disagree with the chairman and say, I disagree with the chairman. I'm not going to say he's occasionally honest. I'm not going to say he never lies. I'm not going to say these things because this is the problem this committee is down and dirty into. This has got to stop. Impeachment took us too far. It's time to get back. We can disagree on this. But when I was told, when there's nobody in this room, even if you agree with the chairman's comments, that's a dispersion on the character of the president, which by our rules is not allowed. It's not allowed. Just like it's not allowed on anything else. So I'm just making a point here because I knew after talking to your parliamentarian they wasn't going to rule what you said out of order. So I'll make the point to say, why don't we all get back to debating this issue in proper terms in ways that you say, this is what's the words on paper, here's what I don't like about it, anything else. I'm willing to do that. I'm not going to say, you're lying or not lying, I'm lying or you're lying. Let's get away from this. But quit taking these pot shots. Let's get back to our regular order. Let's do what we need to do. I would not ever think to say that this chairman occasionally lies or doesn't lie. That's not part of what this discourse should be. But I'm also not going to tolerate it when we cast aspersions and call it policy against this president. We're not going to do it. We didn't do it with President Obama. We're not going to do it here in this committee now. If we continue down this road, this is bad precedent. I yield to the gentleman from Pennsylvania.
I thank the ranking member. I yield to my friend and colleague from Arizona.
I thank the gentleman for yielding. I just want to give some context to the bill and some of the discussion we've heard. In the Visa Waiver Program Improvement and Terrorist Travel Protection Act of 2015, Congress put the travel ban on Iraq, Iran, Sudan, and Syria. Jay Johnson, DHS Secretary under President Obama, in 2016, February 2016, included Libya, Somalia, and Yemen. There's your 7 countries. There's your 7 countries. It was a continuation from the previous administration. That's the context you really need to see. I get it. A lot of folks don't like this president. That's okay. That's okay. This is America. You can do that. You can feel bad about the president. Or you can love the president. But you shouldn't basically say that his travel ban was racially motivated because it continued. The ban that was put in place by Congress in 2015 and under Jay Johnson in 2016, who went back to 2011 and said, if you traveled to these countries since 2011, you got a travel ban. That's the context I wish you'd all remember. Now yield back to the gentleman from Pennsylvania.
My time has expired. I yield back. Thank you.
Chairman.
Gentleman's time has expired. Let me just comment, because I was accused of impropriety a moment ago. We have to have robust debate in this committee. Comments, positive or negative, about the president or anybody else are in order, and I will not permit improper invocations of decorum to restrict free speech on this committee. For what purpose does the gentlelady from California seek recognition?
To strike the last word.
The gentlelady is recognized.
I just wanted to make a brief comment, and then I'll yield to whoever wants to be heard on this. The administration invoked the Congress's action on the visa waiver program as really a pretext for the broad ban. What Congress did in 2015 was to say that if you were a national of a particular country that had been involved in the war with ISIS, that you were not eligible for the visa waiver program. Instead, you had to have an actual interview for a visa. That is far different than saying you're banned from coming to the United States. And I remember in the hearing, this leads to results that are completely irrational. One of the witnesses I believe he was a witness, perhaps just a participant, he was an American citizen. He met his wife at UCLA while they were both getting their PhDs. She was born in Iran, but was actually a Canadian citizen, and she couldn't come in, his wife couldn't come into the United States. I mean, because of this ban. That doesn't make any sense whatsoever. I yield to the gentlelady from California, Ms. Bass, the remainder of my time.
Thank you very much. I support H.R. 2214. Unfortunately, the president has a track record of banning countries with a high Muslim population from entering the United States. In Africa alone, Libya, Somalia, Eritrea, Sudan, Tanzania, and most recently Nigeria have been added to the list of nations facing travel restrictions. One of my colleagues a few minutes ago mentioned Somalia. Somalia, we actually do have an ambassador to Somalia. It is not completely run. Obviously, al-Shabaab is a problem, but the country is not completely run by al-Shabaab. Last month, I traveled to Sudan with members of this committee. Our foreign policy currently, which is led by this administration, had us moving closer to more normal relations with Sudan. So Sudan last year went through a massive upheaval that led to a new government. So while our delegation was meeting with representatives of the new government, we received word about a ban on people from Sudan entering the United States. You can imagine how this was received and how we looked meeting with the new government, encouraging them along, and then they find out a couple of minutes later that they're banned from coming to the United States. So the policy is actually in direct conflict with the direction of the administration's own policy towards Sudan. Last Sunday, I attended the opening session of the African Union in Ethiopia. Leaders from multiple countries approached our delegation completely confused by U.S. policy. So they now question, what is our policy toward the continent of Africa? We simply cannot continue to preach democracy, freedom of speech, and the freedom of religion when we ban people from our country, and regardless of how my colleagues on the other side of the aisle think it is perceived that we are banning people because they have the Muslim faith. I yield the rest of my time. Thank you.
The gentlelady yields back. Who seeks recognition? For what purpose does Mr. Armstrong seek recognition?
Move to strike the last word.
The gentleman is recognized.
And I yield my time to my friend from Colorado.
Mr. Chairman, Mr. Chairman, I'm going to ask the ranking member and the chairman to take down their words, occasionally honest, as they apply to any member of this committee or the president.
Would the gentleman yield?
Yes.
As I did in my statement, I did take back my words. I said this is not the way to do it, and I think we need to do that as we go forward. That's the purpose of what I said, was to get this committee back to a civil tone.
Reclaiming my time, I ask the chairman to do the same.
I'm sorry, I didn't hear you.
To take down your words, occasionally honest, as they apply to the President of the United States.
I will not take down the words. I think they're accurate and they're well within the bounds of comment, of free speech in this committee.
I make a motion then to take down the chairman.
Gentlemen, the gentleman makes a motion to take down the words. He believes that referring to the president as occasionally honest is beyond the purview of free speech in the committee. I rule. I don't want to. I don't. The gentleman's motion is not in. The gentleman's motion is not in order. Or rather, is
Untimely. Untimely. Yield me.
I yield to the ranking member.
I think it is, and the chairman's trying to find the right word. It's called untimely, and the motion is not timely. What we have, again, it's really disturbing because what we've just seen is a weakening, a demeaning of civility that is we've seen forth in this committee. The chairman just agreed that things that we would not have tolerated 6 months ago, a year ago. I mean, it's a sad state in which we've come to, in which it's okay. It's not okay. It's not okay if I do it. It's not okay if any of my members do it. It's not okay if any of you or the chairman or any of your members do it. And this may seem funny and foolish to everybody else watching, but it's not for this body. For this body to operate, there has to be the rules of the House and rules of civility. And you can't cloak it in policy. You can't cloak it in however you want to do it just because, you know, you're upset. That's not the way we do this. And we've done it for well over 200 years in this body. It's here for a reason. The reason we call the gentle lady or the gentleman from another state, the reason we don't do these things is because civility does matter. And I'm not yielding right now because you've already made your statement, Mr. Forson, Mr. Chairman, that you have thought that that was okay, and you're cloaking it under free speech. The rules of the House determine how we can talk to people. Now, if you want to talk about the rules of the House doing, you know, adherence to free speech, then have that argument on your own time. But I'm not sure how you get away with that because nobody else I've ever heard of makes the argument that the rules of the House impinge on free speech. I mean, that's an argument that is frankly, is unsettling. So if we can't have this discussion, get onto this bill, take a vote on the amendments, take a vote on these bills. You're the majority, as I've made the session many times before. You have the votes. You will pass the bill. If you don't, that's your problem for bringing it forward. So I think as we move forward here, that's what the gentleman from Colorado is trying to bring out. That's what I was trying to bring out, is simply at what standard do we keep lowering it? And next week, is there a lower standard? Is there a next week we can say something else? Is there a next week we can say something else? This is a slippery slope, Mr. Chairman, that is beneath this committee, it's beneath the chairmanship, and should not have happened, and should not continue. And I don't want it to continue. But I cannot, as ranking member, sit here on the minority side defending the rights of the minority and the majority, unfortunately, in this case, to continue this process. We've had 2 hearings this year, and they've both devolved into chaos. This looks like last year. Let's get better. It's 2020. But this, I mean, look, you can agree or disagree, and that's fine, but we got to do this in a better way. Language matters. Dispersions matter. And if everybody else took, and if the gentleman from Georgia took my saying that occasionally honest as a dispersion, then that should have been the trigger for everybody here. If it's occasionally dishonest as a dispersion among the chairman, then it should have been a dispersion on the president, because the rule is the same. So I'm willing to let this go. We got a minute and a half left. I could talk about this for us, but why are we in the sand pit on this? Why do we continue this? Talk about it in terms of the bill, talk about it in terms of this bill, and let's move on this vote, and let's quit the civility problem that we have so that we can get better. I respect you, Mr. Chairman. We have worked together for almost 8 years. Don't let this right now in the last 2 hearings divulge into what the legacy is of what we've done in the last 12 months. We can't do this. I yield back to the
Will my
gentleman
good friend yield?
from Colorado.
Gentleman from Colorado's time is long expired. Excuse
There's a
me.
minute left.
Excuse me. The gentleman moved to take down my words. He believes that calling the president occasionally honest is a violation of the rules of the House. I pointed out that the rules of the House, that I do not believe that using that language is a violation of the rules of the House. If it were, then the rules of the House would be against free speech, but they are not. Does the gentleman wish a vote on his motion to take down my words? I do. The gentleman asked for a vote on the motion to take down my words.
Mr. Chairman.
On the motion to take down my words, the clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? No. Ms. Jackson-Lee votes no. Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? No. Mr. Richmond votes no. Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? No. Ms. Demings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Dean? Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins?
Yes.
Mr. Collins votes yes. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Buck votes yes. Mr. Radcliffe? Mr. Radcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler?
Aye.
Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
Has everyone who wishes to vote voted? Clerk will announce the result.
Mr. Chairman, there are 10 ayes and 19 noes.
The motion to take down my words is not agreed to. The gentlelady, for what purpose does the gentlelady from Georgia seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. I thank Congresswoman Chu for leading the No Ban Act, which I'm a proud co-sponsor of. I'm proud that my community, like many communities across America, are made stronger by our faith and stronger by our diversity. My constituents gather around churches, synagogues, and mosques, and we come to houses of worship to search for meaning, to build each other up, and to find refuge. For me, nothing is more important than my faith and my family. And so many Americans and faith leaders completely agree. This legislation is supported by more congregations and religious groups than I can even name here at one time. Organizations that represent Christians, Jews, Muslims, and others who are standing together to reject religious discrimination. These discriminatory bans have had particularly devastating consequences on Iranian Americans in my district. I represent Georgia's 6th congressional district, and I've heard the stories that my constituents tell who came to Georgia in search of a better life, of the American dream. They graduated from our universities, and they secured great jobs. They're contributing to our economy as engineers, medical professionals, and teachers. They became United States citizens, and some are even serving in our military. Yet their families are separated by this discriminatory ban. From our nation's founding through to today, religious freedom is a core American value. But for the families that are affected by these bans, that promise rings very hollow to them. It isn't just our faith leaders who are standing up to these unprecedented bans. Major corporations have opposed the bans, explaining that it hinders businesses operating in an increasingly global workplace. Dozens of national security experts have warned that by focusing on non-threatening individuals and perpetuating harmful stereotypes, we are actually making Americans less safe. This bill will end baseless religious discrimination. It will ensure that our immigration policies are supported by sound and reasonable judgment, and it preserves the president's ability to respond to real threats with consultation with the State Department and Departments of Homeland Security. And I am very pleased to support this bill with my colleagues and to stand up for the preservation of religious freedom. And I yield back the balance of my time.
Gentlelady yields back. Does anyone else seek recognition on this amendment? For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
I wanted to speak to the policy reasons for this bill. Based on personal experience, I have seen the disastrous impact of the presidential proclamations that were issued here. The administration issued a series of proclamations which, at least initially, explicitly targeted several primarily Muslim countries. The proclamations were not well tailored to achieve their alleged purpose, to keep our country safe, and they both went too far and not far enough. They went too far in that they banned large classes of people who posed no threat to our country and broke promises that our country had made to our allies. For example, these orders immediately impacted Afghan and Iraqi individuals who had supported our country, who had worked with our military to act as translators and drivers, and as a result could no longer remain in their countries because they had supported our country. We saw that immediately just yesterday when I took a cab in a rainstorm. My driver was someone who had been a translator for our troops. So those bans immediately impacted those folks who we had promised refuge to. It also impacted Syrian Christians. On the day the Muslim ban took effect the first time, 2 Christian families were landing at the Philadelphia airport, and they were turned back because of this overly broad, poorly conceived ban. The ban also didn't go far enough in that it exempted without explanation certain countries and groups which have posed far greater threats to our country in terms of importing terrorists. And again, those exemptions appeared to be motivated by the president's personal and political interests. There was no ban on people from Saudi Arabia, a country that the president has assiduously courted for a variety of reasons. Congress customarily delegates powers to the executive with broad discretion to exercise those powers in the expectation that the powers will be exercised in a rational and policy-based manner that promotes the national interest. Here, when an administration has failed to exercise that discretion granted by Congress in a responsible or rational manner, it's up to Congress to step in. In this case, it has been widely acknowledged by the administration that these policies were drafted by the president's advisor, Stephen Miller, without consulting the State Department, and therefore it becomes necessary to make sure that the State Department is looped in. If you can't play nicely, you can't have nice things. So therefore, I'll support this bill.
Gentlelady yields back. For what purpose does the gentlelady from Washington seek recognition?
Move to strike the last word, Mr. Chairman.
Gentlelady is recognized.
Thank you, Mr. Chairman. And I thank you for bringing this crucial bill, the No Ban Act, to markup today. I want to be clear about what happened in January of 2017. Donald Trump issued Executive Order 13769 to ban people from 7 Muslim-majority countries. They were Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. I and many of my colleagues rushed to the airport. I believe you were one of the first, Mr. Chairman, on this committee to rush to our airports, our local airports, and what we found was total chaos and heartbreak as countless families suddenly found themselves rejected by this country simply based on religion and unsure of when they would be able to reunite with their families and loved ones here in the United States. The No Ban Act repeals the Trump administration's Muslim ban, and it sends a clear message to Muslim Americans, Muslims around the world, and indeed all those who believe in religious freedom and liberty, regardless of whether you're Christian or Muslim or Hindu, that the United States of America stands with you as a land of religious freedom, a land of fairness, a land where people are free to worship who they choose to worship. The No Ban Act would also ensure that no future president oversteps his or her power to enact bans that discriminate against individuals based on race, religion, or country of origin. Today, the Muslim ban continues to inflict irreparable harm on our families, communities, and businesses. Families remain separated from loved ones, making the simple act of being together an unreachable dream if you happen to be Muslim. As of January 2019, the Muslim ban had prevented over 9,000 spouses and adopted minor children from uniting with their U.S. citizen spouse or parent. Mr. Chairman, there are people speaking behind me and laughing, and it's very disturbing. Could I have silence? Thank you. Employers and colleges are hindered in their ability to attract the best and brightest from around the world simply because these individuals happen to be Muslim. In the last month, at least 3 Iranian students were deported from airports despite holding valid visas. This will make international students think twice about investing in U.S. colleges, and just today, a prospective employee born in Iran is about to have his job offer revoked to conduct research under a National Science Foundation grant because of unacceptably slow processing times. Microsoft, which has many employees in my district and is an important company for this country, has condemned the ban, which could hurt 76 of their employees. And they say that U.S. immigration policy that restricts the flow of people, quote, may inhibit our ability to adequately staff our research and development efforts. In addition, U.S. safety and security depends on our ability to establish mutual trust and understanding with our Muslim neighbors around the world, who are crucial partners in our shared interest in combating terrorism. That is why former defense officials, national security experts, and military veterans oppose the Muslim ban. But perhaps worst of all is the message that we send to our Muslim brothers and sisters, Muslim American neighbors and friends, and those around the world, that America doesn't want them or that they should fear practicing their own religion. I am somewhat astounded that we would have a discussion about decorum of rules in the committee, given what the president continues to say, calling African countries S-hole countries, making statements about Elijah Cummings, our revered former chairman, making statements about black and brown people across the country, casting aspersions on people who come into this country, calling them murderers and rapists. I would love to have a country that practices decorum, and it should start from the United States of America's White House. We shouldn't have a situation where people turn off their televisions because they don't want their kids to hear what is being said from that bully pulpit of the White House. The Trump administration's implementation of the Muslim ban is a dark moment in our history. It calls into question all Americans' basic rights. And the idea that we would conflate a government that perhaps is combating terrorism or perhaps even has terrorist influences within that government with the people of that country is outrageous. We are all trying to fight the worst impulses and the worst influences around the world. And the Muslim ban doesn't do that. So I just want to thank the allies who are here today, Farhana Kira of Muslim Advocates, who has been instrumental in moving this bill forward, Congresswoman Judy Chu, who introduced the bill, Congressman Max Rose, who has been very instrumental in moving this forward. As Democrats, we are united across our caucus to ensure the No Ban Act passes on the House floor. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. For what purposes? The gentlelady from Texas seek recognition.
Mr. Chairman, I move to strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman, and I too rise to speak against this amendment and express my support for the underlying bill. Like my colleague before me, I think it's important that we just look back at what did happen in 2017 when the administration implemented the first travel ban. In nearly 1,000 college students around Texas, where I'm from, were forced to make a choice. Either stay in the United States to earn a world-class education or visit their family and risk being blocked from returning for their studies. This is a choice that aspiring students never should be forced to make. And sadly, they were not alone. Doctors at our Texas Medical Center in Houston, professors at our great universities, engineers at NASA, they were all making the same choice. They were our neighbors, they were our friends, but they had to make a choice. Now in 2020, we have about 35,000 Nigerians in the metropolitan Houston area that will be affected by another travel ban that targets more Muslim-majority countries. These new bans will continue to separate families across many of our districts. These travel bans are not in place because of national security. The bans are simply a tool to discriminate against the Muslim population. Texas is home to the largest and fastest growing Muslim population in the country, and our affected constituents are against this policy, and so is my district, and so am I. The travel ban keeps American citizens from being reunited with their loved ones. Last time this committee had a hearing on this issue, I shared a heartbreaking story about my constituent whose fiance was prohibited from joining her again in Houston. We must end policies like this that lead to heartbreaking stories that are tearing families apart. As a Catholic, I support this bill. It promotes religious freedom and prevents the president from picking and choosing which religions he prefers over another. The bill draws on a simple topic we all learned in school: checks and balances. This bill does not inhibit the president from maintaining national security. It only requires that he have a credible reason for such future policies. National security, of course, is of utmost importance, but we can maintain security without discriminating against an entire community. The Muslim ban was arbitrarily implemented before President Trump could even finish moving into the White House during his very first week after inauguration. These hasty and overbroad bans promote xenophobia and fulfill a campaign promise of hate. H.R. 2214 is vital to preventing future abuses, and I urge all my colleagues to support it, because when this thing happens, if it does, we are all Muslim. Thank you, and I yield back my remainder of my time.
Gentlelady yields back. Does anyone else seek recognition on this amendment? For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman's recognized.
Mr. Chairman, thank you for holding this important markup of the No Ban Act, and I oppose the amendment. This legislation is designed to repeal the discriminatory and xenophobic Muslim ban and to prevent future abuses of executive power that undermine one of our nation's founding principles, freedom of religion. In the face of religious intolerance, Roger Williams established the great state of Rhode Island on the principles of religious liberty and separation of church and state. Thanks to Williams' leadership, Rhode Island became a haven for religious minorities and inspired the framers of our Constitution to incorporate these important principles into our foundational documents. And in 1790, President Washington visited the Hebrew congregation of Touro Synagogue, the oldest synagogue in North America, and then followed up with a letter to the congregation when they asked about whether or not they would be allowed to exercise their freedom of religion in this new country. And the president wrote those famous words: "The government of the United States, which gives bigotry no sanction, to persecution no assistance." In that letter, President Washington reassured them that America would be a place where religious freedom would be recognized and they would be free to exercise their own religious traditions. President Trump has told us exactly what he did when he created the Muslim ban. The clear intent from the beginning has been to keep out as many people from Muslim-majority countries as possible, regardless of whether they are seeking refuge or asylum. This plan was never designed to make us safer, but merely to spread hate and fear and further divide us as a nation. Over 55 former intelligence and national security officials from Republican and Democratic administrations, dozens of top-ranked retired admirals and generals, a former Republican attorney general, and a Republican chairman of the 9/11 Commission all oppose the Muslim ban as hostile to American values and an overreach of presidential power. The Muslim ban has had a real and lasting impact on families across the country. Over 130 Syrian refugees who escaped hell on earth have resettled in Rhode Island. But because of the Trump administration's Muslim ban, they now live with the stress of not knowing whether they will ever see their loved ones again. This is unacceptable. People across the country are waiting in a constant state of limbo, including wives waiting to join their husbands here in America, fathers who have missed their children's births, and students who are seeking to study at our great universities. This is unacceptable. The ban also threatens to worsen healthcare shortages in rural America. For instance, Iran, Syria, Libya, Somalia, Sudan, and Yemen, 6 of the 7 countries originally banned, accounted for more than 7,000 physicians practicing in the United States. And in 2015, Iran and Syria were 2 of the top 10 nations that supplied the United States with physicians. A 2017 analysis by a team of Harvard and MIT economists found that doctors from nations targeted by the ban schedule an average of 14 million patient visits each year. This is unacceptable. And just last month, while President Trump was tweeting about supporting Iranians after the killing of General Soleimani, his administration was actively blocking Iranians from seeking asylum and refuge here. This is unacceptable. The No Ban Act makes it unequivocally clear that we stand by the American ideals of freedom of religion. It provides necessary limitations on the president's ability to use overly broad language to inappropriately and indiscriminately target and label entire groups of racial, ethnic, or religious minorities because of who they choose to worship. We must not tolerate discriminatory actions that undermine our core values and threaten our nation's health and safety and security. I urge my colleagues to support the No Ban Act, and I would ask unanimous consent, Mr. Chairman, to introduce the following articles. The first is an article from April 24th, 2018, entitled, "Why Dozens of National Security Experts Have Come Out Against Trump's Travel Ban."
Without objection.
I ask unanimous consent that an November 10th article entitled "Syrian Refugees in Rhode Island Feel Strain of Family Separation"
Without
be introduced
objection.
into the record. Another article by Physician Diversity entitled "Travel Ban Threatens to Worsen Access to Care" be included in the record.
Without objection.
And finally, an article entitled "Trump's Travel Ban is Worsening Healthcare Shortages in Rural America" be introduced into the record.
Without objection.
With that, Mr. Chairman, I yield back.
Gentleman yields back. Does anyone else seek recognition on this amendment? The question then occurs on, for what purposes does the gentleman from California seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized.
Thank you, Chairman Nadler. When the president first took office, he soon introduced a Muslim ban. I immediately went to LAX to try to help the travelers who were stranded at the airport and had been denied entry into this country despite having been approved by the State Department. Thereafter, I introduced the Dire Legal Aid Act, which would have provided federal grants to nonprofits to provide legal counsel for such immigrants. Prior to this administration's extreme vetting process, the State Department had a vetting process in place that had been used by previous presidents to keep individuals of questionable character out of this country. I say that if we wish to remain a beacon of freedom to the world, we must stand for justice and equity in addressing immigrants and refugees that continue to look to the United States for hope. We can't just claim we are the greatest nation in the world, and we can't just claim we are a just nation. We have to actually act like one. I'm the original co-sponsor with the Rep. Chu's bill, No Ban Act, and I urge my colleagues to pass this bill. And Chairman Landler, thank you very much, and I yield the remainder of my time.
Gentleman yields back. The question occurs on the amendment, on the Biggs amendment. All in favor say aye. Aye. Opposed, no?
No.
The amendment is not agreed to. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes yes. Mr. Sensenbrenner? Mr. Sensenbrenner votes yes. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes yes. Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Radcliffe? Mr. Radcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
Has every member who wishes to vote voted? Ms. Jackson-Lee?
Am I recorded?
Ms. Jackson-Lee, you are not recorded.
I vote no.
Ms. Jackson-Lee votes no.
Mr. Raskin?
Mr. Raskin, you are not recorded. Mr. Raskin votes no.
Mr. Deutsch?
Mr. Deutsch votes no.
Mr. Johnson?
Mr. Swalwell, you are not recorded. Mr. Swalwell votes no.
Mr. Johnson of Georgia?
Mr. Johnson of Georgia votes no.
Has everyone who wishes to vote now voted? The clerk will report.
Mr. Chairman, there are 13 ayes and 22 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute?
Mr.
Gentleman for what purpose does the gentleman from Colorado seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2214, offered by Mr. Neguse of Colorado. Page 6, beginning on line 21, strike 9645 and 9822, and insert 9645, 9822, and 9983.
The gentleman is recognized for the purpose of explaining his amendment.
Thank you, Mr. Chairman, for holding this hearing, for bringing up this bill. My amendment is very simple and straightforward. It would add President Trump's latest travel ban to the underlying bill. As has been discussed today during the markup, on January 31st of this year, the Trump administration issued a new presidential proclamation that will ban the issuance of immigrant visas for nationals of Burma, Eritrea, Kyrgyzstan, and Nigeria, as well as suspend participation in the diversity visa lottery for nationals of Sudan and Tanzania. I want to start by saying, in my view, each version of President Trump's bans have run counter to our American values and ultimately to our morality and our humanity. And I know a bit earlier, one of my colleagues on the other side of the aisle described the debate around this particular bill as nothing more than rhetoric. And I couldn't disagree more. And I say that because I offer this amendment not just as a member of this committee and as a proud American, but as the son of immigrants, from Eritrea, one of the 6 countries that is included in this new ban. My parents came to this country nearly 40 years ago. They became naturalized citizens, and they never forgot or took for granted the freedom and the opportunities that this incredible country gave them and their children. I understand the often difficult circumstances that have led many to seek shelter, refuge, and a home in the United States. At our core, we are a nation of immigrants. As a nation, we are not defined by one single characteristic, but rather by our shared commitment to an ideal, to an opportunity that our parents, grandparents, and generations have fought to secure. More than 50 years ago, Congress eliminated country bans from immigration law, and it did so because those policies in particular were undeniably discriminatory. Unfortunately, it seems clear this president seems intent on revisiting that disgraceful period of our country's history. In my view, the ban is an attack on our core American values. In America, immigrants are integral parts of each of our communities. They are our friends, they are our neighbors, they are our colleagues. And it is un-American to discriminate against immigrants solely because of how they pray. It is incredibly important that Congress preserve and promote the continued ideals of the United States as a land of immigrants, strengthened by our differences. The first step in preserving that legacy is passing Representative Chu's No Ban Act. By passing this bill out of committee with this amendment and onto the House floor, we are affirming that the United States is still committed to fairness, non-discrimination, and human rights, and that ultimately the United States will continue to be a beacon of hope to the rest of the world. So I urge all members of this committee to support my amendment and the underlying bill, and I thank you and yield back the balance of my time.
Does anyone seek recognition on this amendment?
Chairman.
Gentleman from Wisconsin. For what purpose does the gentleman from Wisconsin seek recognition?
In opposition to the amendment.
Does the gentleman wish to strike the last word?
I do.
Gentleman is recognized.
Mr. Chairman, this amendment, by expanding the no entry list to the latest January 31st presidential proclamation, has nothing to do with religion. And I want to make this perfectly clear. You know, what the gentleman from Colorado and the supporters of this bill are saying is that we are attempting to deny entry to people who practice the Islamic faith. There are other factors involved in whether someone is admitted to the United States or not. And I want to look at the problems with the countries that are in this amendment. Burma. Burma does not comply with the established identity management information sharing criteria assessed by performance metrics. Eritrea. Eritrea does not comply with the established identity management and information sharing criteria assessed by performance metrics. Kyrgyzstan. Kyrgyzstan does not comply with the established identity management and information sharing criteria assessed by performance metrics. Nigeria, the same. Sudan, the same. In addition, presents a high risk relative to other countries in the world of terrorist travel to the United States. Tanzania does not comply with established identity management and information criteria assessed by performance metrics. Now, I would hope that everybody in Congress, particularly my friends on the other side of the aisle, would agree that we ought to know who's coming to this country before they are admitted, and that way we can keep out people who do not meet, or whose countries do not meet, the identity criteria that have been established and have been vetted. This amendment does away with that. It has nothing to do with religion, whether one is of the Islamic faith or other faiths, or does not practice a faith at all. It has to do with identifying people who may cause harm to American citizens and visitors who do comply. And that's why this amendment, I think, is particularly bad, because what it does do in the name of religious freedom, which I will stand up for anytime, any place, anywhere, when it really is attempting to ban people who will not share identity information and other relevant information with our consular officials when they are interviewing and adjudicating visa applicants. This is a question of security. It's not a question of discriminating against people who practice Islam. And I would point out that in each of the countries that have been mentioned, there is a considerable non-Islamic population. They're banned too, because their countries have not ended up making the proper representations to our State Department that they can identify people who would do harm to Americans and those who are visiting should they be admitted to the United States. So let's cut the rhetoric saying that this is a religious freedom bill. It is not. Let's cut the rhetoric that this is a religious freedom amendment. It is not. Look at what it does and vote no. And I yield to the gentleman from Georgia.
I thank the gentleman for yielding, and I just want to add to what, how you've basically described this, because in looking at these restrictions that we've talked about that were the most recent restrictions, these restrictions are appropriately tailored, and they're not just broad. For example, Tanzania and Sudan are only restricted with respect to diversity visas. The other countries only had immigrant visas and not non-immigrant visas restricted. This is because the immigrants are more difficult to remove if problems are discovered after admission than non-immigrants. Also, this is actually working, as I said in my opening statement. The restrictions are already working to bring up a higher security compliance. Nigeria has already met with U.S. officials and is working to come into compliance. This is working and having the desired effect for security overall, not just with our country, but with the world. And with that, I yield back to the gentleman from Wisconsin.
Mr. Chairman.
I yield back.
I recognize myself in support of the amendment, rather. The amendment simply updates the bill. The bill says you can't enforce the Muslim ban and lists the various iterations of it. The amendment simply adds the latest amendment promulgated a couple of weeks ago to that list. The real question is not on the amendment. The real question is what everybody's been debating, including Mr. Sensenbrenner a moment ago, which is the bill itself. This bill is clearly a Muslim ban. Now, all the reasons that we've been told that it isn't a Muslim ban, that it's to protect our country from this or that, are pretextual. The president himself told us that when he said that he was going to institute a Muslim ban. Period. He was honest. He couldn't get away with that in court, so he started looking for excuses. And that's what these are. Now, you can look at any of these things they say about Eritrea or Kyrgyzstan or Nigeria, and they're true of many other countries too. They're totally arbitrary and pretextual. This is a Muslim ban. You may want to pretend that it isn't, but it is. It is ugly. It is disgusting. It is unworthy of the United States. And we should be honest and admit what it is and pass this bill to get rid of it and remove the stain in our country. I yield back.
Would the gentleman yield?
Certainly I yield.
I would just like to make a couple of points in support of the amendment. First, the argument about compliance with information sharing, I think, is misplaced and the part of the administration pretextual. For example, Somalia is in compliance, but is still subject to the ban. Iraq is not in compliance, but is not subject to the ban. So, and there are other ways in the code to deal with legitimate security concerns. I want to mention this, and I do think when the president said he wanted a Muslim ban, and he said it many times and tried many times, it is not wrong for us to think that's what he was trying to do. That's what he said he was trying to do. And if you look at the expansion, there are substantial and in some cases majority Muslim populations in these countries. Eritrea, 48%, Kyrgyzstan, 86%, Nigeria, 51%, Sudan, 97%, Tanzania, 45%, and as to Burma, the individuals who are subject to the ban are primarily those who have fled or who are refugees, the Rohingyas, who have been abused by the country and the military in Burma. I think it's very telling that the latest ban applies only to people, to green card applicants and not to non-immigrants. If this were about security, it wouldn't allow visitors to come in, but not physicians coming in on a green card application. So the idea that this is about security in some ways, I think was really belied by the proclamation itself. I do think that the addition of these countries suggested by the amendment is important. And, you know, I think we are blessed to have, as a member of our committee, a fabulous congressman and lawyer whose own parents would have been barred from coming to the United States under the latest ban because they were from Eritrea. So I appreciate the amendment. It's well taken. I think the arguments that I'm sure advanced in good faith just are incorrect because by the terms of the proclamations themselves belie the arguments that are being made in support. And with that, Mr. Chairman, I yield back to you.
General Lady yields back. I yield back. Does anyone else seek recognition on this amendment? For what purpose does the gentleman from Texas seek recognition?
Strike the last word.
Gentleman's recognized.
Yeah, I couldn't agree more and appreciate the chairman's statement that we need to be honest. And I agree with that, and I'm looking forward to when we can get there with everybody. This is not a Muslim ban. I don't know how many in this committee have had the chance to sit down for 2.5 hours behind closed doors with the head of intelligence in Egypt, as I have. But these Muslim friends of ours, they have concerns about our failure to use common sense about who we let into our country, because our Muslim friends in different countries around the world, they use common sense, and they know it's not smart to be letting people in that may be wanting to destroy your way of life. And if someone is coming from a country where we can't ascertain whether or not they are a threat because of that country's security, then it's not a good idea until we do ascertain that. I don't know how many of y'all have met multiple times with our former Northern Alliance in Afghanistan, as I have numerous times. But these are our Muslim friends. The enemy of our enemy is our friend, and they are our friends. But they acknowledge that at times we are just stupid in the United States, not recognizing that there are people who want to destroy our way of life. And I understand there's this feeling that, we need to love everyone and be open, and that gets people killed if you're not, as a government, providing security, which is part of our oath to the Constitution. We are supposed to protect this place, and we're not doing that. I don't know how many of the people in this room have sat and wept with mothers of daughters who were kidnapped in Nigeria in a safe house, as I have. But they think we're nuts when we let people into this country without knowing whether they're a threat or not. Of course, they also couldn't understand why they couldn't get more help fighting Boko Haram without having to change their marriage laws and their abortion laws to accommodate the prior administration. They thought perhaps we would be willing to help without them having to change their religious convictions, but that's another matter altogether. The point is, there are people around the world, including in countries that are on this ban, that think we're nuts in this place, because we are to be fighting to let in people whom we do not know. And it's interesting, many of the arguments I'm hearing right now, it's a Muslim ban, were said about when there was a ban on people from Syria after ISIS took over the printing presses of the passports in Syria. I mean, they took over control of so much of that area. We had no idea who was coming in, and yet we heard those same things. It's a Muslim ban. No, it was a ban on people coming from Syria because we didn't know who had legitimate passports and who did not, who was coming in as a threat to this country and who was not. So hopefully at some point we will arrive at being more than occasionally honest in this committee. And we'll get to the point where we can disagree over what will make us safe without calling others racist or anti-Muslim or all these things. We will talk about, does this make us safe? Does it not make us safe? And set aside all the nasty name calling, because there is a desire and there is a need to protect this little experiment, self-government. And there are people around the world, including in the countries I've mentioned, where I've visited with leaders, many of them Muslim, that make clear, if you guys don't protect liberty, your freedom in your country, we have no chance. It's going to be gone. So let's talk about defending liberty without all the name calling, and then we can all be assured that we're more than occasionally honest in this committee. I yield back.
Gentleman yields back. Who else seeks recognition? The gentleman from, for what purpose does the gentlelady from Texas seek recognition?
Thank you, Mr. Chairman. I rise to strike the last word. Let me express my friendship for all of those on the other side of the aisle and try to undo the comments of my good friend from Texas that we are here protecting liberty and justice, which is one of the reasons why we're so astounded by the actions yesterday that occurred with respect to the interference of a legitimate trial and conviction. But at the same time, I think it is important to edify the various countries that have been part of the new ban, and to thank the gentleman from Colorado for his very thoughtful amendment, and also for his personal history that I believe brings a great deal of insight to this committee. Belarus I've been to. I'm familiar with the family or the various constituents and various immigrants who've come from Myanmar. Eritrea, my predecessor, the Honorable Mickey Leland, died on the side of an Ethiopian mountain taking food to the starving people in that region. Kazakhstan, Nigeria, Sudan, and Tanzania all have challenges. But as has been indicated by my colleagues, some of them are clearly in compliance. Tanzania, we visited and saw a thriving small business community. Nigeria, I happen to be the co-chair of the Nigerian caucus, the largest, with my colleague, who is a member of this committee from Ohio, Republican colleague. It is well known about Boko Haram. I have been to the epicenter of Boko Haram. I have hugged the families, cried with the mothers, and hugged the young women who were able to escape and continue to fight every day for those young girls to be brought back. One of the reasons why you see members of Congress wearing red on this day is to bring the girls back. But Nigeria is now the largest economy and most populous country in Africa, with an estimated population more than 190 million. It's expected to grow to 400 million by 2050, 375 billion united domestic product. It is the largest foreign investor. The U.S. is the largest foreign investor in Nigeria. Yet, as I indicated earlier, the president said that if the people from Nigeria coming out of their huts come to the United States, they'll never go back. The diversity visa has worked for decades, and I too believe in knowing who is in our country. We have that process going. We have a very detailed and extensive consular program that is not very apt to allow people in. I hear it all the time. We fight to have family reunification. This Muslim ban will ban students and doctors, lawyers. It will ban business persons. It will ban humanitarians. It'll ban people who have been friends with the United States for a very long time. And so I think it is appropriate that the amendment that the gentleman has goes to this order after Ms. Chu has put forward this very important bill where many of us are co-sponsors. His amendment will now cover this present order, precipitous, and it does have an unfortunate odor of distaste. But in any event, it will cover this order and allow us to case by case assess this issue. Let me explain to you the pain of the initial issuance of the Muslim ban. As I was at Bush Intercontinental Airport, when families were crying because their unsuspecting relatives were getting off of planes and being held in detention. They did not know what had happened. They had left their countries with the appropriate documents. They were coming to the United States. And one in particular was a young Egyptian boy by the name of Ali. And he had traveled by himself, 15 years old, to come to visit his uncle. He had been in the United States on, yes, a tourist visa, and went back home to make sure that his documents were timely and dated and appropriate. He got another tourist visa for another couple of months. He was held. His lawyers were not able to see him. Yes, while he was here, our school districts, who don't ask such questions, had allowed him to come to learn English. And he is a young boy. And when he was asked the question what he was doing here, he was a teenager. He said, I'm glad, truthfully, that he had gone to school. But he was away from that family for close to 3 to 6 months. Our office got involved because he was sent to Chicago to a detention center. Yes, that is what happens to the Muslim ban. That's why I'll be offering my amendment about reporting. But it is a deadly or devastating impact to families with no seeming criteria for why this administration listed these countries. I support Mr. Nagu's amendment. It is a right-thinking, right-directed amendment that is going to correct an ill and a wrong. We know who's coming into this country, and we know who's done damage in terms of terrorism on this country and from what particular country. None of these that are on this list in the last decades have perpetrated a terrorist act against any American. Isn't that interesting? I ask my colleagues to support the amendment. I yield back.
Gentlelady yields back. For what purpose does the gentleman from Pennsylvania seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I yield to my friend and colleague from the great state of Texas.
I thank my friend. I realize the majority is apparently settled on constantly calling this a Muslim ban, but I hate for people to think that colleagues on the other side of the aisle don't know demographics, just ignorant in some of these areas. But Nigeria, for example, it's not all Muslim. And anybody that's been there surely has to know that about half the country is Christian. So if people from Nigeria are banned until they get their identification system working properly so that we can let people in, it's not just a Muslim ban. It's a ban on Christians, on Jews, on secularists, on anybody in these countries. And there are Christians in some of these other countries, and I would submit in all of them. Some of them have to stay really low below the radar, but they are there. And no thanks to the UN. But if we're going to get more than occasionally honest in this committee, then there's going to have to be the honest admission that this is not a Muslim ban, because there are many other people besides Muslims, and many of the Muslims in these countries are dear friends of ours. They support us, they appreciate us, and so it is a way of forcing better accountability from those countries, and our Muslim friends in those countries would like to see greater accountability within their own countries as well. That would help them be safer as well. So I hope that at some point we can get beyond the name, the unofficial name that apparently the majority has agreed on, and that's Muslim ban, and go, yeah, well, I guess if we're going to be more than occasionally honest, we're going to have to say it's not just a Muslim ban, it's a ban on specific countries that have other religions in them as well. So hopefully we can get these countries to fix their identification process. But if they don't, we still have an obligation to the people in this country. And I realize there are those that love sanctuary cities and just turn a blind eye when someone is killed in those cities from by someone who shouldn't have been here. And yes, we know we don't need lectures to know that all people that have come in illegally into this country are not threats. But the fact is there are a lot of murder victims, rape victims that would not have suffered had this country and states and cities done a better job of keeping their oaths. And so we're hopefully going to get to the point where some, at least in here, on the other side of the aisle will admit, yeah, you're right. It's not just a Muslim ban. It's a ban on people in countries where we can't trust their identification system. And I yield back to my friend.
Thank
Thank you, Mr. Chairman. I move to strike the last word. Thank you. I speak in support of this amendment, and I thank my colleague and classmate from Colorado for this thoughtful amendment, and I thank you, Mr. Chairman, for the underlying bill. I want to push back on the false argument that you have been hearing, that somehow because people of other faiths are caught up in the web of a Muslim ban, that it is somehow not a Muslim ban. I think anybody of common sense and logic gets that. Just because folks of other faiths, from Eritrea, from anywhere else, are caught up in the Muslim ban doesn't make it not a ban. And here's how we can prove that. We can use the president's own words. The president said, since the early days of his campaign, he's openly declared his selective adherence to the foundational principle of, let's hear what he said, before he entered office, quote, Islam hates us, end quote. The president said, quote, we're having problems with Muslims coming into this country, end quote. During the first week of his presidency, President Trump made good on his prejudice promise. He issued an executive order entitled, quote, protecting the nation from foreign terrorists' entry into the United States, end quote. And the president said, quote, we all know what that means. You know what? A bipartisan coalition of national security officials, including Secretary of State Madeleine Albright, former CIA and NSA Director General Michael Hayden, they told us this ban does nothing to advance our national security interest. In fact, they warned us it makes us less safe. Yet after 3 attempts by this administration, they were able to paint the Muslim ban with just enough veneer of legal legitimacy to narrowly survive a challenge in the Supreme Court. When the Supreme Court failed to protect our founding principles from executive abuse, Congress remains the first and foremost branch of government. I'm pleased that today we're taking a vital step to right this historic wrong imposed by the president. Thank you, Chairman Nadler, for holding this markup. Deep gratitude goes to Representative Judy Chu, Senator Chris Coons for championing the No Ban Act. This bill does more than simply terminate President Trump's Muslim ban and his refugee and asylum bans. It does more than ensure future presidents cannot act similarly atrocious policies. It declares that there are still people who believe in our national scripture etched onto the Statue of Liberty, give me your tired, your poor, your huddled masses, yearning to breathe free. We have a chance to say here that America remains a beacon for those seeking a home, to practice whatever faith or no faith, to raise their families, to be members of our diverse fabric of America. I hope all my colleagues will take that chance and vote for this bill, support this amendment, and vote for this bill, because these are our American values. With that, Mr. Chairman, I'd like to yield to the gentlelady from Texas, Ms. Garcia.
Thank you for yielding. And Mr. Chair, I unfortunately had to step out and go speak on an item at Financial Services, and I missed the vote on the Biggs amendment. I would like the record to reflect that I would have voted no.
The record will so reflect. With that, the committee will stand in recess until 2 o'clock. The committee will come back to order. We were discussing the amendment. The gentlelady from Florida, Ms. McCarcel-Powell, is recognized.
Thank you, Mr. Chairman. I support Mr. Negus's amendment in the underlying bill. We can't forget about the human toll and the real impact that these bans have on our communities across the country, including my very own district in Florida's 26th district. Leaders in my district are anxious about this policy and the consistent attacks on Muslims by this administration. I share their strong belief that these discriminatory approaches don't reflect our American values and they're counterproductive. I recently had a conversation with Naveed Anjum, who's the vice chair of the Islamic School of Miami, and we spoke about the shared values that connect all Americans across cultural lines. One of the most central being the fundamental principle of religious freedom. Mr. Anjum told me that his students realize the value of these principles in the United States. They come here because of it. They work through the systems and the laws with the hopes of becoming contributing members of our communities. But the ban runs counter to all of these beliefs and has caused needless harm for so many. Mr. Anjum recounted the heartbreaking tale of a lawyer in my district who is hesitant and scared to go visit her 81-year-old grandparents in Iran. She's afraid that if she leaves to take care of them, she won't be able to re-enter the United States. And then I want to bring attention to Ahmed Al-Najjar. He's 29 years old. He's a doctor who is studying and working at the University of Miami Hospital. He spent his childhood in Syria, but was forced to flee with his family due to the ongoing conflict. Ahmed's family ended up in different parts of the world. In 2016, he applied to come to the United States, but was delayed because of the Muslim ban. Ahmed finally, in 2017, was able to come to the United States to work and study. But because of his Syrian nationality and the ban, his family remains abroad, and he's here alone. To make things worse, Ahmed's sister was tragically killed last year while living in Saudi Arabia. Her name is Aya. She's right here. Ahmed did not travel to her funeral because he was scared that he would not be able to re-enter the United States. Bright young minds, valuable assets to our community. They are being punished because of these arbitrary and discriminatory policies. Sadly, these stories are not unique to my district or my community. A 2019 study showed that the bans have prevented more than 9,000 family members of U.S. citizens from entering the country, including more than 5,500 children. The Muslim ban is born out of fear and cowardice, not real policy. This is not about national security or information sharing. These policies are cruel and they discriminate against individuals because of their religious beliefs. These immoral bans run counter to the philosophy of religious freedom instilled in our Constitution, and they run counter to the shared American values that Mr. Anjum and I strongly believe in. We cannot allow policies like this to stand, and this is why I support your amendment, my friend, my dear friend and colleague, Mr. Negus, and the underlying bill, and I urge my colleagues to do the same. I yield back.
The lady yields back for purpose. Does the gentleman from Arizona seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I appreciate that. I am regretfully going to have to oppose my friend Mr. Negus's proposed amendment. I've heard a number of different arguments today, such as the bans that the administration has issued are not well tailored to fulfill the stated purpose of the bans. And yet somehow it was said that the U.S. Supreme Court was gullible in granting or upholding those bans. We just heard that those bans were described as arbitrary, discriminatory, fearful. They were an emblem of cowardice, that they were immoral. And yet, the bans themselves, the ones that are subject to the proposed amendment that we're talking about now, they don't even discuss religion at all. Instead, the nations mentioned, Burma, Eritrea, Kyrgyzstan, Nigeria, Sudan, Tanzania, all engage in or prevent the sharing of established identity management systems. Nigeria has acknowledged that they have a problem, and they're trying to work it out. When Chad was placed on the list previously, they actually made changes necessary and came off the list. There are also waiver provisions, and I understand that those are difficult because the burden of proof is on the party seeking waiver. That I agree. That's can be very difficult and very time-consuming sometimes. But the underlying bill, with all that's going on here today in our discussion and how it's been characterized, would have you believe that the stated purpose or the actual result itself was an exclusive Muslim ban, and nothing could be further from the truth. The U.S. Supreme Court itself acknowledged that the president lawfully exercised discretion based on his findings following a worldwide multi-agency review that entry of the covered aliens would be detrimental to the national interest. Further, the Supreme Court itself noted that the text of EO 13769, PP 9645 says nothing about religion. And the policy covers just 8% of the world's Muslim population as limited to countries that were previously designated by Congress or prior administrations as posing national security risks. I am curious what the arguments were under previous administrations when those bans were first implemented. I'm not sure that we would, if we were to play the tape back, we would see the same kind of rhetoric that we see today. So I'm gonna stop there and just say that I regretfully must oppose this amendment, and I will yield back, Mr. Chairman.
Gentleman yields back. For what purposes? The gentlelady from Washington seek recognition.
Move to strike the last word, Mr. Chairman.
Gentlelady is recognized.
Thank you, Mr. Chairman. I'd like to thank my colleague, Congressman Neguse, for this amendment, but also for your sharing the impact of something like this on your own family. I think we sometimes divorce these policies from what they actually say to people around the country, and I appreciate your sharing your personal story. I do believe that this amendment is critical and we should pass it. This expanded ban applies to people from Burma, Eritrea, Kyrgyzstan, and Nigeria, and also suspends people from Sudan and Tanzania from participating in the diversity visa program. So whether you want to call it a Muslim ban or not, the reality is that 5 of these 6 countries have significant Muslim populations. And the idea that this is being done for security reasons or because we want to fight the threat of terrorism is a continued red herring. And I would just quote from a 2018 study by the Libertarian Cato Institute that found that the Trump administration's, quote, extreme vetting of travelers and immigrants, of which the travel ban is a centerpiece, would not significantly reduce the already tiny risk of imported terrorism, but would come at exponentially greater cost. In July of 2019, the same institute also said that the risk of any American being killed in the United States by refugees or immigrants is negligible. So let's not conflate this with smart policy that takes on any real threats in the United States. We had the FBI director here, and he talked about the growing threat of domestic terrorism. We have real problems that we should deal with, but that doesn't come by discriminating against countries that have Muslim majority populations or drawing some sort of a false correlation between people in those countries and whatever we might say that the governments may or may not do. I wanted to specifically speak about a couple of the countries in this expanded Muslim ban or African ban, however you want to talk about it. Sudan, my colleague Representative Bass mentioned that we had a bipartisan congressional delegation to Sudan just a few weeks ago with members of this committee, and it was so incredibly inspiring to see the civilian protests that overthrew a 30-year brutal dictatorship and the transition of that dictatorship to a civilian-led government. That, at the exact same time as they are trying to move in a very fragile time, the new Sudanese government is trying to move towards democracy, something that the United States cares deeply about around the world, that we would be in country when news of the fact that Sudan was going to be added to this list came out. Now, people don't realize how important the diversity visa program is for African countries in particular. It was designed specifically for countries that have lower immigration rates, and so a lot of Sudanese utilize the diversity visa program because it is one of the few ways that Sudanese individuals can have access to the United States. So this is a terrible message to send to Sudan. Moreover, Burma's inclusion is deeply troubling given the harm that would come to Burmese refugees, including the Rohingya, a Muslim ethnic minority group that is facing genocide. In the last 10 years, 1 in 4 refugees coming to the United States have come from Burma. And of course, this administration has cut refugee admissions, something that has been a bipartisan agreement, something that the evangelicals have called the crown jewel of American humanitarianism in the world. But this administration has cut refugee admissions. So here we are now also adding Burma to this list. Since fiscal year 2012, Burmese nationals have actually made up the largest nationality group among refugees coming to the United States, now unable to do it in that means. None of these countries appear to have even been notified or talked to about what they needed to do to comply if this was about complying with certain U.S. restrictions. The Nigerian Minister of Culture and Information said there was no discussion with them about what they needed to do if they were not in compliance. On top of that, I think we should think about what this means for the United States' relationship and global position of leadership in the world when we are doing some of these things. Just as an example, Nigeria is being avidly courted by China for its One Belt, One Road initiative, and if the United States continues to be an unreliable, to say the least, partner, we have to understand that that's going to have implications for our global partnerships and relationships around the world. And finally, I would just say that I get tired of hearing about all of the terrible things that immigrants are apparently doing. There are so many studies that show that immigrants contribute to our country. Unless you are Native American, somewhere in your family's history, you have some connection to immigration to this country. And I think that the dual loyalty that many of us are also being put through if we're naturalized citizens, that we'll get to that in the next bill, is extremely disturbing. And I would hope that it's something that our members on the other side of the aisle would agree with us on as well. Thank you. I yield back, Mr. Chairman.
Gentlelady yields back. The question now occurs on the amendment. All in favor of the amendment, say aye. Aye. Opposed? No. The ayes have it. Roll call. Roll call is asked. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Aye. Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar? Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomer? Mr. Jordan? Mr. Buck? Mr. Radcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stube? Mr. Stube votes no. Ms. Demmings, you are not recorded. Ms. Demmings votes aye.
Are there any members who wish to vote on the bill? Mr. Cohen?
Mr. Cohen votes aye.
Mr. Jackson Lee?
Mr. Chairman, how am I recorded?
Ms. Jackson Lee, you are not recorded.
Aye.
Ms. Jackson Lee votes aye.
Ms. Swalwell?
Mr. Swalwell, you are not recorded. Mr. Swalwell votes aye. You are not recorded. Mr. Jeffries votes aye. Mr. Buck votes no. Mr. Chairman, there are 19 ayes and 8 noes.
Mr. Chairman, I have an amendment at the desk.
I reserve a point of order.
Clerk will report the amendment. The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2214, offered by Mr. Biggs. Page 3, line 7, insert before the semicolon the following: except that this subparagraph shall not apply to the case of a restriction or suspension based on a determination under paragraph 1 related to the security.
The amendment will be regarded as read. Mr. Biggs is recognized for the purpose of explaining his amendment.
Thank you, Mr. Chairman. H.R. 2214 requires that the President, requires the President to, quote, narrowly tailor the suspension or restriction using the least restrictive means to achieve such compelling government interest, close quote. I submit that the President should not have to use the least restrictive means necessary when that compelling interest in particular is the national security of the United States. The United States faces threats, both foreign and domestic, and 212F authority is but one tool available to the President to protect our country. Requiring that we not use every tool at our disposal within reason to protect our country seems absurd. Legally requiring a minimalist approach will constrain the government's ability to identify solutions to the national security concerns our nation faces. We should not use only the least restrictive means necessary when ensuring the integrity of our elections. We should use all means necessary. We should not use the least restrictive means necessary to ensure that terrorists do not gain entry into the United States. We should use all means necessary. This amendment is very simple. It states that the requirement of narrowly tailoring the suspension using the least restrictive means is not applicable when the compelling government interest is the security of the United States. The President, as the executive, should have this authority to be able to respond nimbly to any number of threats our country might face, or as a tool to compel foreign actors to conform to behavior conducive to U.S. policy goals, and should not be so severely limited when it comes to safeguarding our national security. If my colleagues take seriously our national security, then I urge them to vote for this amendment to ensure that 212 authority will be utilized to protect the security of America in the future. And I would add a few additional comments. And I would say that data that we've been given by the State Department shows that between December 8th, 2017 and October 31st, 2018, there were 149,121 visa applications, immigrant and non-immigrant total, from nationals within the countries affected by PP 9645. Of those, 8,149 were refused visas based on a reason unrelated to the PP. 2,578 qualified for an exception under that provision. 24,584 failed to meet the waiver criteria. 36,309 were refused after waiver consideration, and 2,216 applicants met every condition of the waiver criteria and were granted waiver. I would suggest that that data may not conform to everything that you're hoping to accomplish with this bill, but that it indicates very clearly that this is not meant to be some kind of blanket ban, which is perhaps one of the reasons why the United States Supreme Court upheld that ban, is because they said, they meaning the justices of the Supreme Court, noted that a systemic, worldwide, multi-agency review had been performed. And they pointed out that the people contesting the ban were attempting to identify conflict with other provisions in the INA, and they were unable to do that. And they were also unable to demonstrate some kind of discriminatory ban based on religion. And they duly noted, and this is appropriate to argue, that religion was not even mentioned in any of the proposals that had resulted in the ban. I would suggest that my amendment here is primarily meant to allow the president, regardless of whatever party they may be from, to have some kind of limited use, but nonetheless effective use, to protect the national security of the United States of America, which I think is one of our main responsibilities, as well as one of the main responsibilities of the president pursuant to Article 2 of the Constitution. So I would urge everyone to please vote yes for this amendment. And with that, I'm going to yield to the ranking member.
And I just wanted to say thank you for this amendment. I look forward to supporting it, and thank you for the logical reason. I think this is the issue of security. We continue to look at that, and I appreciate the amendment. Yield back.
I recognize.
Thank you. I'll yield back, Mr. Chairman.
Gentleman yields back. I recognize myself in opposition to the amendment. There are all kinds of policy reasons, which I assume the Ms. Lofgren will articulate. But for me, let me just say that this is another amendment that seems to have no effect whatsoever. Just a cursory reading of the bill says that the main bill says that the Secretary of State, in consultation with the Secretary of Homeland Security, when he determines that there's a threat to national security, the President may do various things. In carrying out paragraph 1, the President and various other people may do various things, including specify the duration of the, may narrowly tailor the suspension, that in doing those things, he shall narrowly tailor the suspension or restriction using the least restrictive means to achieve such compelling government interest. In other words, he can do certain things so long as he determines that what he's doing will achieve the end, which is presumably is protecting the national security, and B, is doing so in a manner that he determines is using the least restrictive means of doing so. The amendment says, except that this paragraph shall not apply in the case of restriction or suspension based on determination under paragraph 1. In other words, the bill says the President shall do such things when he determines there's a national security threat, and he shall do it in the least restrictive means that he determines he can do. The amendment says that he can do it in the least restrictive means or not. He determines what the least restrictive means are. The amendment will have no effect whatsoever. He's limited to the least restrictive means that he determines under the bill. This says he doesn't have to do it. He determines it in any event, so this amendment seems to do nothing at all. I'll yield to the gentlelady from California.
Thank you. I think this amendment is unnecessary and actually counterproductive. The bill already allows the President to suspend the entry of a class of individuals if he determines that such individuals, quote, would undermine the security or public safety of the United States or the preservation of human rights, democratic processes or institutions, or international stability. That is very broad language, and by design, we do think it's important for the President to have broad authority to protect the country. But at the same time, this bill recognizes that the executive branch should not be permitted to use Section 212F to essentially rewrite immigration law completely. And a good example of this was the first ban that the President issued. He cited Section 212F as the legal authority to render all southern border crossers ineligible for asylum if they do not come through a port of entry. Well, Section 208 of the Immigration and Nationality Act says this, quote, any alien who is physically present in the United States or who arrives in the United States, whether or not at a designated point of arrival, irrespective of such alien status, may apply for asylum. That is, I mean, You know, when people say, what are we going to do about the Remain in Mexico program? We're going to enact a law. It's in the law. And the president purported to use 212F to essentially vitiate the rest of the immigration code. As Judge Teeger said when listening to the case, quote, the rule irreconcilably conflicts with the Immigration and Nationality Act and the expressed intent of Congress. Whatever the scope of the president's authority, he may not rewrite the immigration laws to impose a condition that Congress has expressly forbidden. So these limitations would prevent that. And I would like to say that the president, in addition to the broad authority that's granted under this bill, has other sections of the law that'll give him broad authority to protect the country. For example, 212A3 of the Immigration and Nationality Act also provides broad authority to exclude individuals from the United States for national security-related reasons. For an individual to be barred from the United States under 212A3, all there needs to be is a reasonable ground to believe that the individual presents a risk to national security or is entering to engage in any unlawful activity. So I think that this amendment should be opposed. We adequately and robustly provide the executive with the tools to protect the country, but we're going to curb the tendency to use Section 212F to rewrite the rest of the Immigration and Nationality Act, and I yield back.
Gentlelady yields back. For what purpose does the gentleman from Pennsylvania seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. I yield to my friend and colleague from Arizona.
I thank the gentleman for yielding. I just want to bring up a couple of points in response to my colleagues, the chairman and the knowledgeable chairman of the subcommittee. The first point I guess I would make is that I think part of the reason that this amendment becomes necessary is because you didn't support my First Amendment. And the First Amendment would have actually preserved the executive authority of the President of the United States instead of making the president's authority subordinate to two unelected, unaccountable, effectively, cabinet officials, which makes it kind of odd. And then you move to the two here, the limitations that are placed on the president. And on page 3, line 5, so subparagraph B there, we're talking about narrowly tailor the suspension restriction using the least restrictive means. I thought I heard the chairman indicate that term least restrictive means is effectively without meaning, which I find interesting because we use that term in various places in the law. And it has been adjudicated and has legal meaning. And one of the things that it will do, it will require certain types of acts on the president. Now, certain constraints on the president's actions. The reason that that's important is because there isn't anybody that's sitting on this dais, I would assume, that doesn't disagree with this statement, that these provisions will be litigated. They're going to be litigated because just kind of the way the language is tailored, and because should this pass. If this doesn't pass, it's not going to get litigated, obviously. But if it were to be passed and signed into law, which it won't be, but if it were, this language would really be a hotbed of judicial activity. I guarantee that. So, and it leads to finally the last point. If the language using the least restrictive means really is without meaning, then the line narrowly tailor the suspension or restriction to achieve such compelling government interest probably should be satisfactory. That should probably satisfy what you're asking for. Because if you're the ones who said the language itself is effectively without meaning, well, if that's the case, then support my amendment, toss out the language that doesn't have any legal implication in your mind, and then you'll have maybe a more effective bill. So with that, I'll yield back to the gentleman from Pennsylvania.
Thank you, and I would yield to the Ranking Member Doug Collins.
Well, I think the gentleman from Arizona makes an interesting point, but it also is an interesting point from the chairman's perspective. This amendment does mean something, although the chairman and the others said it effectively does nothing. Well, if it effectively does nothing, then you're rewriting prose in the same way that you've already written the bill, so why not accept it? Well, that's just false, because it will change something. And so instead of just writing it off as an amendment that didn't need to be made or an amendment that has no meaning, you could have accepted it, because if it has no change or has no meaning, then that's basically an argument in denial of the fact that it does change something. But I think the gentleman from Arizona is correct about one thing. And when you look at the terminology issue here, there is defined terminology. There is vagueness, though, however, in the way it's used here, is that you are setting up, and I mentioned this in my opening statement, on the bill. You're setting this up for litigation. You're setting this up for basically in many ways this will be very good for a profession of which I'm involved in. I'm a lawyer. It's very good for lawyers. This is a Lawyer Full Employment Act. It will give you every opportunity to go to court and use these vague terms and use these other issues in this. But I do find it amazing. That is a legitimate argument about the bill that the gentleman is trying to face. But I do think it is interesting that the chairman's reaction to this was, well, it doesn't really change anything, so what does it matter? Well, if it doesn't matter, accept it. That's a great point for bipartisanship. Accept something that doesn't change the inherent nature of your bill. The problem is it does change it, because it clarifies portions here that we have. And with that, I yield back to the gentleman from Pennsylvania.
Thank you. I yield the remainder of my time.
Gentleman yields back. With that, the vote occurs on the amendment. All in favor of the amendment, say aye. Opposed, no. No. The noes have it. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Mr. Collins? Yes. Mr. Collins votes yes. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomer? Mr. Jordan? Mr. Buck? Aye. Mr. Buck votes aye. Mr. Radcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Aye. Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Aye. Ms. Lesko votes aye. Mr. Reschenthaler? Aye. Mr. Reschenthaler votes aye. Mr. Klein? Aye. Mr. Klein votes aye. Mr. Armstrong? Yes. Mr. Armstrong votes yes. Mr. Stubbe? Yes. Mr. Stubbe votes yes.
Has everyone voted who wishes to vote? Mr. Jeffries?
Mr. Jeffries votes no.
Mr. Gates?
Aye. Mr. Gates votes aye.
Anyone else? The clerk will announce the results. Mr. Jordan?
Yes. Mr. Jordan votes yes. Mr. Chairman, there are 11 ayes and 18 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? For what purposes, the gentlelady from Texas seek recognition? The gentlelady has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2214, offered by Ms. Jackson Lee of Texas. Page 7, line 18, strike 9645 and insert 9645 and
Without objection, the amendment
9983.
will be considered as read. The gentlelady is recognized for the purpose of explaining her amendment.
I thank the. This is not the correct amendment. No, it's not. Yeah, it isn't. This is what it looks like. That amendment is not going to be presented. Yeah.
Little stay, we do, the clerk, this is the wrong amendment.
This one?
Stand down for a moment until we get the right amendment.
Thank you.
Not this one?
No problem. I looked at it and said it got a little longer than what I thought it was.
The gentlelady is now recognized for the purpose.
I thank the chairman. I
explaining
thank
her
the
amendment.
gentlelady from California for her leadership, and I thank Mr. Neguse for giving us the opportunity to vote on a very thoughtful amendment. And my amendment brings into this, hopefully, successful legislation, the No Ban Act, the provisions that were included in the 2017 executive order, and that is the reporting factors to assess why the government feels that there are no other pathways to deal with some of the concerns that may be expressed by way of the assessment that is made by the Secretary of Homeland Security and in consultation with the Secretary of State and Director of National Intelligence. They use three categories that we've heard our colleagues say, which is a criteria to assess national security and public safety threats, whether a foreign government engages in reliable identity management practices and shares relevant information, whether a foreign government shares national security and public safety information, and whether a country otherwise poses a national security or public safety risk. I would venture to say that most of us who've had the experience with countries around the world realize that there are many, many countries around the world that have not been banned, and in fact may not meet the criteria that I've just enunciated. So let me try to share with you some of the countries that have been banned and see if you can appreciate that they are on the pathway of trying to comply. Kyrgyzstan indicates they've had some challenges, though it has been responsive to the United States diplomatic engagement on the need for improvements. Nigeria. The Department of State has provided significant assistance to Nigeria as it modernizes its border management capabilities, and the government of Nigeria recognizes the importance of improving its information sharing with the United States. It's put on the Muslim ban list. Why? For example, Sudan now issues electronic passports and has improved its coordination with Interpol in several respects. It's now put on the ban. Muslim country. Tanzania. It goes on to suggest that Tanzania has challenges. Tanzania does, however, issue electronic passports for all major passport classes, reports lost and stolen travel documents to Interpol at least once a month, and has provided exemplars of its current passports to the United States. And it is put on the no travel ban. It baffles me as to what the basis of this new executive order is. Is it a distraction? Is it a blame the other fellow incident that we continue to have? Is the same old from the administration? Here are countries that are actively engaged with the United States in trying to improve their own conditions. That's stated in the president's executive order right here. But yet they're put on the list in January 2020. So that I guess the young man from Egypt, there'll be further individuals who have traveled and didn't know what they were going to confront, and they're held in detention. This particular amendment allows us to have a report as to the impact by the ban. Who is impacted? What families will be divided? What college students? What businesses? What diplomatic engagement? What exchange students? What families seeking to come to bury a loved one? Who will be impacted, and does that impact make the nation safer or make it more unsafe? Does it create more enemies in the face of the world, or does it in fact make us safe? So, as I said, my amendment is simple. It provides for a reporting feature to the No Ban Act to ensure that we have the full impact, which would be both the negative impact that would undermine the international efforts of this country to engage in discussions on improving border capacities for the many countries that we engage with, and be able to help them be a friend of the United States and continue to improve the processes that they have. I'm baffled again by this particular order by the President. I support the No Ban Act, and I ask my colleagues to support the Jackson Lee Amendment.
Question occurs on the amendment. All in favor of the amendment say aye.
Aye.
Aye. Opposed? The ayes have it. Are there any further amendments to the amendment in the nature of a substitute? The question then occurs on the amendment in the nature of a substitute.
Move to strike the last word.
For what purposes, the gentleman seek recognition?
Move to strike the last word just to speak on the amendment.
Which amendment?
In the nature of the substitute.
Oh, gentleman is recognized.
Thank you, Mr. Chairman. I want to state my very strong support for the No Ban Act. As I listened to my colleagues today, I was reflecting that it's very easy to lose what makes you most special, like your Constitution, your rule of law, your democracy. America is an immigrant society, and America is an open society. The colonists arrived here as undocumented aliens, but they were overwhelmingly welcomed by the Native Americans when they got here. And the Pilgrims had big hopes and big dreams as refugees from religious oppression and monarchies. They created a constitution devoted to religious liberty and political freedom. James Madison said that America would become an asylum for humanity. Not an insane asylum, mind you, but an asylum for humanity, a haven of refuge for people fleeing from religious and political persecution from all over the world. They built a constitution that embodied the ideals of liberty and equality. And that's what our Constitution is today. Free exercise of religion, no establishment of religion, equal protection of the laws, no bills of attainder, no collective guilt, due process, no mass punishment, no racial, religious, and ethnic profiling of entire populations. But I want to agree with my GOP colleagues about one thing. The Muslim ban is a bit of a misnomer. The Muslim ban is an outrageous affront to our constitutional values, to the free exercise of religion, to no establishment of religion, to equal protection of the laws, and so on and so forth. But it is a bit of a misnomer to talk about a Muslim ban. It's true that the travel ban applies to tens of millions of Muslims, the vast majority of whom are completely innocent. And my colleague from Washington is surely correct that the president's ban overwhelmingly and disproportionately applies to people from majority Muslim countries. But I've got to say that my GOP colleagues are right about one thing. It is a bit of a misnomer to talk about a Muslim ban because there are not only a few majority Muslim countries that are not on it, but not on it are also some official Islamist theocratic monarchies where Sunni Islam is the state religion and Sharia is the law of the land, which are not on the list. Take, for example, Saudi Arabia, an authoritarian police state which oppresses women. I think they just got the right to get their learner's licenses for driving a few months ago. But otherwise, women are second-class citizens in every way. It imprisons people for heresy, apostasy, blasphemy, and other imaginary religious offenses. It's considered a Tier 1 country of concern under our government's Commission on International Religious Freedom rankings of the worst violators of religious freedom on earth. It bans the public practice of any religion other than Islam. It conducts weekly beheadings in Riyadh in so-called Chop Chop Square, and it promotes its extremist, fanatical, Wahhabist version of Islam through madrasas, schools all over the world. Saudi Arabia provided the vast majority of the 9/11 hijackers, and most recently sent a Saudi citizen and naval airman to train at a U.S. naval base in Florida where he massacred 3 people. So you might think Saudi Arabia would be at the top of the president's list, but no, not at all. Saudi Arabia is an oil monarchy run by billionaire kleptocrats. These are Donald Trump's people. He knows how to do business with people like that. I'm going to submit for the record an article from the Washington Post, headline, Trump's Most Consistent Foreign Policy, Defending Saudi Arabia.
Without objection.
When we tried to cut off funding for the brutal Saudi war against the people of Yemen, Trump rose to defend them. When Congress passed several resolutions to block billions of dollars in weapon sales to Saudi Arabia and the United Arab Emirates, President Trump vetoed them. And when the UN Security Council passed a resolution drafted by Britain demanding Saudi accountability for war crimes in Yemen, Trump's team stopped it. And he's defended the homicidal crown prince of Saudi Arabia at every turn, including apologizing and defending his behavior in the disgraceful assassination and dismembering of Jamal Khashoggi, a Washington Post journalist. So where's the ban on those people? Where's the ban on Saudi Arabia? So I support this legislation with everything I've got, and I deplore the hypocrisy and the collaboration of this administration with murderous regimes like Saudi Arabia. I yield back.
Gentleman yields back. The question now occurs on the amendment, the nature of a substitute as amended. This will be followed immediately by vote on final passage of the bill. All those in favor of the amendment, the nature of a substitute as amended, respond by saying aye. Aye. Opposed, no. The ayes have it. In the opinion of the chair, the ayes have it. The amendment, the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2214 is amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. And the ayes have it, and the bill is ordered reported favorably. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. Escobar? Mr. Collins?
No.
Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Radcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Has everyone voted who wishes to vote? Mr. Deutsch?
Mr. Deutsch votes aye.
Mr. Johnson of Georgia? Is Mr. Johnson recorded?
Mr. Johnson is recorded.
Okay.
Mr. Jeffries, you are not recorded. Mr. Jeffries votes aye.
Ms. Demings?
Ms. Demings is recorded.
Is anyone else who wishes to vote? Okay, the clerk will report the results. Ms. Bass? Ms. Bass voted?
Ms. Bass votes aye.
Clerk will report.
Mr. Chairman, there are 21 ayes and 10 noes.
The ayes have it. The bill is amended, is ordered reported favorably to the House. Members will have 2 days. Mr. Cicilline. Mr. Cicilline's vote will be recorded as aye, and the bill is still reported to the House favorably. If they get here one day, they will be recorded. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 5581, the Access to Counsel Act of 2020, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5581, to clarify the rights of all persons who are held or detained at a port of entry or at any detention facility overseen
Without
by
objection,
the...
the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 5581, the Access to Counsel Act of 2020, represents an important step in addressing a significant lack of due process occurring at our ports of entry. The failure to provide access to counsel and other types of assistance for individuals subject to secondary inspection. Immediately after the Trump administration issued its first version of the Muslim ban in January 2017, I went to JFK Airport, along with my colleague from New York, Representative Nydia Velasquez, to assist individuals arriving with lawful permanent residence and other valid visas who are undergoing the inspection and admissions process. The situation at the airport was chaotic and heartbreaking. Refugees, persons with valid visas, and even lawful permanent residents were detained for hours by CPB and were prevented from speaking with attorneys. Some even had their phones taken away and were refused permission to call their family members. This included American citizens, this included green card holders, it included everybody. According to a DHS Inspector General report released on the one-year anniversary of the ban, CBP went even further, ignoring a court order mandating that lawful permanent residents who were swept up in the ban have access to counsel. CBP skirted that order by hiding behind a regulatory provision that says the right to counsel does not apply to inspections at ports of entry. The Inspector General concluded that CPB's highly aggressive stance, unquote, in response to the court orders was questionable and troubling. This is an understatement. On September 24, 2019, the Immigration Subcommittee held a joint hearing with the Foreign Affairs Oversight and Investigation Subcommittee to explore the implementation and aftermath of the ban and to further develop the need for legislation. However, the urgency of this legislation has become even more clear in recent weeks. As the actions of this administration continue to sow chaos at our ports of entry, access to counsel during the inspection process remains a pressing issue. Just last month, I was deeply concerned to learn that as tensions between the United States and Iran were escalating, numerous Iranian Americans, American citizens of Iranian extraction, were held at the Blaine Port of Entry in the state of Washington for hours on end. Reports also indicate that a significant number of Iranian students have been held for many hours at airports only to be summarily deported. Some of these students were unable to contact anyone on the outside, including the university where they are enrolled, for assistance. Our immigration laws are extremely complex, and yet admissibility determinations, which can have life-altering consequences, often turn on conclusions that can be difficult for CBP to resolve in a high-pressure environment with an unrepresented applicant who is alone, unfamiliar with our laws, and may not be English proficient. That is why this legislation is so important. H.R. 5581 allows applicants for admission to communicate with counsel or an interested party who can help facilitate the inspection process. Counsel and interested parties will be able to provide additional information and documentation to the inspecting officer, as well as provide support, and in the case of counsel, legal advice to the applicant to ensure their rights are protected. All individuals seeking to enter the United States, even U.S. citizens, must go through the inspection process. That is why this bill, which is fundamentally about protecting due process, is one that we should all embrace. I would like to extend a special thanks to my friend and colleague, Representative Jayapal, for her leadership on this issue and for introducing this important legislation. I urge all my colleagues in this committee to support the Access to Counsel Act. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. I oppose H.R. 5581, the Access to Counsel Act of 2020. Many of my Democratic colleagues and interest groups who support them have made no mystery of the fact that they believe that foreign nationals have a right to come to the United States and that they should receive all taxpayer-funded counsel at every stage of the process. The Democrats understand that this is a bridge too far to outright repeal the Immigration and Nationality Act provision prohibiting taxpayer-funded counsel during removal proceedings, but H.R. 5581 is the majority's way of testing how far they can go. The bill mandates that the DHS Secretary shall ensure that an individual who has been selected by Customs and Border Protection for secondary screening at a port of entry has a meaningful opportunity to consult with counsel and be an interested party during such screening. It is important to understand exactly what secondary screening is, why it is used, and the ramifications that this bill would have on the port of entry operations. My Democratic colleagues have provided this committee no opportunity to hear from DHS experts about any of these issues. There has been no hearing on this legislation or even generally on the subject matter at hand. In our conversations with CBP, they shared with us that they were extremely concerned about the impact such a requirement will have on processing at ports of entry. Many of us have been to airports and seen the long lines of passengers from abroad waiting to be processed. We have been to land ports of entry and seen lines of passenger vehicles and cargo trucks that wait hours for the opportunity to enter into the U.S. H.R. 5581 would exponentially increase those processing and wait times. Secondary inspection is used at ports of entry to give the CBP officials time for additional screening that may take longer than a normal case. It can include more in-depth questioning, additional database searches, and physical searches when an individual is suspected of carrying contraband. Secondary inspection is done in an area near the primary inspection booths and serves to remove those whose admissibility may be in question from the primary inspection line so it is not to slow it down. The vast majority of people admitted in the United States do not get referred to secondary inspection, but annually over 17 million do. How, of course, slowing down of trade and traveling processing isn't the only concern of H.R. 5581. Under current regulations adopted in 1980, applicants for admission are not entitled to representation in primary or secondary inspections unless the applicant has become the focus of a criminal investigation and has been taken into custody. But this bill gives all applicants for admission to the U.S., including non-immigrants and lawful permanent residents, a new statutory right to counsel. This idea is based on the belief that everyone has a right to enter the U.S., and it is first step toward what many of our Democratic colleagues want ultimately, and that would be taxpayer-funded counsel for foreign nationals. I would urge my colleagues to oppose H.R. 5581 and yield back the balance of my time.
I now recognize the chair of the Subcommittee on Immigration and Citizenship, the gentlelady from California, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. Markup of this bill is important to ensure that individuals who lawfully present themselves at ports of entry are treated fairly. The bill would simply allow individuals to communicate with counsel or their petitioning employers or persons or other interested parties if they're subject to prolonged inspection. Now, the Immigration and Nationality Act lets individuals in removal proceedings have the right to counsel at their own expense. Federal regulations extend this right to immigration-related examinations. Applicants for admission, specifically those in primary or secondary inspection, are excluded unless, as the ranking member has pointed out, they're subject to a criminal investigation. You know, the immigration laws of the United States are very complex, and fact-intensive nature of questions that are asked regarding admissibility. You know, it's uncommon, not uncommon for people to be held in secondary inspection for a very long time. I mean, I've met people who've been held for 8, 9 hours. Their families don't know what's happening to them. They're their families have gone out and hired a lawyer, but they can't communicate with the person. And there's really no good reason for that. As the chairman has mentioned, oftentimes individuals who have lawfully presented themselves at a port of entry have their phones taken away, and just the access to information is absent. I do think it's important for the Border Patrol, CBP, to make sure that they have the full set of information before them when making a decision, because there can be very severe ramifications when a mistake is made. People who are seeking asylum, and I know there's an amendment on that to come, we've recently had a report, are returned to be murdered in the places where they are fleeing from. We have individuals who have been admitted to PhD programs in some of the finest universities in the United States. They followed all the rules. They have their student visa, and for some reason, they get held up and they can't, the school that's waiting for them can't communicate with CBP. Programs are disrupted, and what is gained to not have the full information. So I think this is really a simple and long overdue measure. It is good for the U.S. economy. Employers will have an opportunity to communicate with a prospective employee. It takes a long time to actually qualify someone who's got an advanced degree, who's coming in to do a job that you couldn't find an American to do, and to not have access to the employer who's waiting for a critical employee, that doesn't make sense. And this would avoid that result. Some individuals may be permitted to withdraw their admissions, applications for admission and return home if they can't convince CBP that they're eligible. But without understanding the rules, if you don't ask for that, in some cases you're removed, and that removal can result in preventing you from coming back to the United States legally for 5 years for doing nothing wrong. You got the visa from the U.S. consulate, you came, you were turned away for reasons you don't understand, and now you're barred for some reason. That's not a good result, and that's not an orderly process.
The gentlelady yield?
I would be happy to yield.
Thank you. In addition to everything that the gentlelady from California is saying and that I said, I just want to point out one thing. All this bill does, people who present themselves at points of entry are entitled to counsel. This simply moves up to a very short time period when they're entitled to counsel. And it may be a million different reasons. It may be an American citizen who needs counsel to clear up confusion. All this bill does is say that anyone who presents himself has an entitlement to counsel as soon as he's detained rather than a little later. And that person may not have a valid reason to be in the country, in which case he'll be deported, or maybe he does, maybe he or she has a visa, maybe he or she's an American citizen, maybe there's been a bureaucratic mix-up. All this does is say that people in that situation have a right to counsel to help straighten out the situation. I wish it said, as Mr. Collins said, that all people who come to this country have a right to tax-supported counsel, but it has nothing. It doesn't say that, unfortunately. It has nothing to do with that. All this says is that counsel, which is now guaranteed, this clarifies that they're guaranteed immediately as opposed to a little later. And counsel may be not necessary. It may be the person may in fact be an alien who has a good right to be in the country, maybe an alien who doesn't have a good right to be in the country, maybe an American citizen who the identification got somehow mixed up and he needs a lawyer to establish that. We don't know. All this says is you're entitled to a counsel. I yield back to the gentlelady.
Reclaiming my time, I just would like to complete my statement and mention that although this is delineated as a right to counsel bill, and it does allow you to call a lawyer. It also allows you to call other people. You could call your mother. you could call, your employer, so that you're not in complete isolation, and there's really no good reason for that. And as the chairman has just mentioned, there is no right to paid counsel in this provision or in any other provision of immigration law. You have no right. You have a right to bring a lawyer to immigration court with you, but you don't have a right to a free lawyer. We've argued that in the case especially of small children, we should take a look at that. But the state of the law today is there's no free lawyers in the immigration system, and this does not change that. And with that, I would yield back the expansive amount of time I've been
Gentlelady
granted.
yields back. I now recognize the ranking member of the Immigration Subcommittee. Mr. Book is not here. All right. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5581, offered by Mr. Nadler. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be enacted as considered as base text for purposes of amendment. I now recognize myself to explain the amendment. The changes in this amendment are necessary to clarify the intent of the underlying legislation and to focus on its primary purpose, to ensure that individuals who present themselves for inspection at ports of entry have access to counsel and other outside assistance. Although the underlying bill seeks to ensure that individuals detained at ports of entry are held in the least restrictive conditions and are provided with access to food and water, this committee has already considered legislation that would deal with the issues of such conditions in a more comprehensive manner. H.R. 3239, the Humanitarian Standards for Individuals in Customs and Border Protection Custody Act, which passed the House on July 24th. Because of this, the amendment strips Section 3 of the bill, which contains the provisions relating to detention provisions and is now superfluous because of the earlier legislation. The amendment also rewrites the access to counsel provisions of the bill. The underlying bill amended Section 292 of the Immigration and Nationality Act, which dealt with the right to counsel for individuals in removal proceedings. To make it clear that the procedures afforded to applicants for admission at ports of entry are separate and distinct from those accorded to individuals in removal proceedings, the amendment makes no changes to Section 292 and instead amends Section 235, which deals with the inspection and admission process. Briefly, the amendment adds a new subsection E to Section 235. This new subsection would require the Secretary of Homeland Security to ensure that, quote, covered individuals who are subjected to prolonged inspection can seek outside assistance from counsel or other parties. The amendment limits covered individuals to those with appropriate immigration documents presenting themselves for lawful admission at a port of entry. In addition, recognizing that lawful permanent residents have a unique attachment to the United States and have rights that should not be hastily signed away, the amendment prohibits DHS from accepting a record of abandonment of LPR status during the inspection process without first providing the individual with the opportunity to seek advice from counsel. In sum, the changes made in the amendment narrow the scope of the bill to focus on its primary purpose and clarify the bill's intent. I urge support of the amendment. I will now recognize the ranking member, the gentleman from Georgia, Mr. Collins, for any comments he may have on the amendment.
Thank you, Mr. Chairman. I appreciate it. And I think the interesting thing about these two bills, and I think the nature in which they were brought forward, I respect the majority's ability to bring these forward. But again, between the chairman and the chairman of the subcommittee is conflicting answers about this. Even the ranking member of the subcommittee said that they want to see counsel provided, and that's the taxpayer expense. And I think the interesting issue, though, is from the chairman's perspective, and I think this is important. These folks are not detained. A secondary screening is not detained. We keep calling this a detention. It's not a detention. A secondary screening is not a detention. My other question here is 17 million of these secondary screenings a year. Are we just going to, how are we going to have a attorney present at all these? I think this may be the one thing, and I don't mean this too tongue-in-cheek, but I do, that maybe where the chairman and I actually agree. This is a free enterprise bill. Have attorneys sitting there waiting for the call for the secondary screenings, because they're going to make a lot of issues and a lot of money at this. Because 17 million of these happen every year. This is not a detention. This is a first step toward what I believe it was sort of bannered back and forth here, but not admitted to, is a full taxpayer funding of this issue, which is not in the code itself. And if we want to change the code, then let's go after the code. Let's don't go around the circle here and try and get at it. But again, your game, your bill, your votes.
Would the gentleman yield? Would the gentleman yield? Thank you. I am just curious, as I read the bill, I found myself saying, I wonder if anybody's got a CBO score on this. You've got 17 million folks that you're now going to make eligible for a government-paid-for attorney or taxpayer-paid attorney?
No, that's.
Oh, they're not government-paid? Who's paying them? So that makes it even more miraculous, doesn't it?
Is that a question?
Oh, very good.
The gentleman asked me a question?
No, I'm actually opining, just
Okay.
ruminating right here on the microphone, Mr. Chairman. And
If the gentleman will yield, I can answer that question.
yeah, I'll yield. Yeah, happy to.
So my job before coming to Congress was to coordinate pro bono attorneys from around the country who go and represent these folks for free. Hundreds of free legal attorneys are going to represent folks in Brownsville, in the Remain in Mexico program, at Lumpkin Detention Center in Georgia, because they recognize that the rule of law is important and that what's happening to these detainees is a violation of human rights.
Okay, I'll reclaim my time. Thank you. I appreciate that you organized hundreds of attorneys, but your pool is now 17 million folks. And I did defense work, criminal defense work, and I am finding it almost unfathomable to imagine how many pro bono hours you think you're going to need to solve this. Yeah, I'll yield back to you.
With the gentleman yield, I want to just enter, because you brought up something interesting here. Now, of course, they'll say, well, there's no taxpayer fund, these are private attorneys. What happens with the first person who comes through under this bill who can't find an attorney, no one shows up, and they sue because their right to counsel was not there? Then you're opening this entire thing up.
Will the gentleman yield?
We're discussing right now. Thank you, Mr. Chairman. It's my time.
Gentleman yield?
It's my time.
It's actually his time, Mr. Chairman. Yeah, I mean,
So, I mean,
yeah.
this is
So when you create a vested right now, and I think of Gideon v. Wainwright, and the outcome of that, now you have just an incredibly expensive program. I'm just curious at what my colleagues think is going to happen. What do you think?
When I think coming back, Mr. Biggs, I think what's happening here is why this should have been a hearing. Should have had a hearing on this bill. I mean, even if you get it, because you got the votes. The majority has the votes. We seem to forget that around here. They have the votes to pass a bill. But have a hearing and hear from CPB. Hear my scenario that I played out, whether you agree with it or not. If there is this right to counsel, then there are a lot of great attorneys who do this for free, and I'm proud of them. They need to. But the what-if scenarios are not at a markup. The what-if scenarios are at a hearing. And we don't have that. So I think the best thing for many of us to do is we watch this happen. This train is on the tracks. Call your vote, vote it, but don't forget the majority over here has raised some valid complaints. I yield back.
Lady from Washington is recognized. Would she yield for a moment?
Sure, I would yield.
Thank you. I just wanted to answer the question from Mr. Biggs, and that is when we requested the CBO score. We requested a CBO score on this bill the same day that we requested a CBO score on the $1 trillion Republican tax cut. I yield back to the...
Thank you, Mr. Chairman. I wish my colleagues would actually read the bill. That would be really helpful. I'm proud to be here today to mark up H.R. 5581, the Access to Counsel Act. The bill would simply make sure that U.S. citizens, green card holders, and others who have legal status in the United States are able to consult with an attorney when CBP detains them in secondary inspection for more than an hour. The plain text of the bill is very clear. DHS shall ensure that covered individuals have a meaningful opportunity to consult with counsel and an interested party during the inspection process. That's it. This was the very first bill that I introduced, actually exactly 3 years ago today, as a member of Congress in 2017 in response to President Trump's Muslim ban that unleashed total chaos at airports across the country as people from 7 Muslim-majority countries suddenly found themselves being deported and in some cases pressured to sign papers giving up their legal status. When I rushed to my local airport, as soon as I heard what was happening, I found a U.S. citizen woman waiting to welcome back her husband who had been put on a plane without being allowed to see an attorney despite traveling on a valid visa. In another case, we literally stopped a plane on the tarmac in order to stop 2 people from being sent back. What we learned afterwards was that CBP detained people in secondary inspection without a phone call, without being able to call an attorney. And CBP wouldn't tell us a thing about how many people were detained in real time. I literally had to go across the airport tarmac to CBP's office to pound on the door to demand answers, and ultimately, it was a court order that helped us secure the release of people being detained across the country. More recently, however, we've seen again the enormous problems that exist for people who are detained in secondary inspection without any ability to consult with an attorney. In January, my office was notified that CBP at the Blaine, Washington northern border crossing was detaining up to 200 people of Iranian heritage. What do I mean when I say detaining? I mean the passport was taken away, the car keys were taken away, they were put in a small room and not allowed to speak to anybody else. To me, that sounds like a detention. The vast majority of these people were U.S. citizens and lawful permanent residents, some of whom had even had expedited screening passes that already require extensive security screening to go across the border. These individuals were detained for up to 12 hours in secondary screening without access to attorneys, and simply because of the country in which they were born. The CBP director has now admitted this after a leaked memo and after numerous press conferences that I held with members who were affected, and after, honestly, some whistleblowers as well submitted information. They admitted that this is what happened. One of these individuals' name was Nega Hekmati. She is a naturalized U.S. citizen, the mother of 2 U.S. citizen children. Nega told me how she and her family were detained for about 6 hours. In spite of their Nexus cards that facilitate expedited travel, they go back and forth across the northern border all the time. One of the most heartbreaking things is that her small children begged her not to speak Farsi anymore because they felt like maybe it was the fact that she was speaking Farsi that had her detained. That is just heartbreaking to me. As one of only 14 naturalized citizens in the United States Congress, this does hit home to me. In 1942, America imposed a second loyalty test on Japanese Americans, interning 123,000 Americans of Japanese ancestry. It took decades for Congress to finally apologize and recognize that was wrong, and yet here we are again, somehow saying that just because of the country of your birth, you are now suspect. We should learn just this one thing, that we should not be imposing these second loyalty tests on people for the sole reason of the country of their birth. In addition, since August of 2019, dozens of Iranian students with valid visas have either had their visas revoked or been deported upon their arrival in the United States, apparently simply because of their country of origin and despite their valid visa status. These situations and others that came up during our September hearing on the Muslim ban made it clear why we need to pass the Access to Counsel Act. We are not asking for these attorneys to be funded by the government or for every single person who arrives to have access, just simply that people who are U.S. citizens, legal permanent residents, legal status, to have the right to make a phone call and consult with an attorney that is paid for by them or provided by nonprofits. Mr. Chairman, I yield back, but I do have ask unanimous consent to enter into the record. Thank you. 3, can I just say what they are because I think they're important, Mr. Chairman, for the record? Yes. Thank you. 2017 Vera Institute of Justice evaluation of the New York Family Unity Project, a universal representation pilot program in the Varick Street Immigration Court that found an 1,100% increase in cases ending successfully due to universal representation. A 2014 Transactional Records Access Clearinghouse at Syracuse University report that found that whether or not an unaccompanied minor had an attorney was the single most important factor influencing the case's outcome. A 2016 American Immigration Council report that found that only 37% of immigrants have legal representation in their removal cases, and those with representation are twice as likely to obtain the relief they sought. Thank you, Mr. Chairman. I yield back.
The question is on the amendment in the nature of a substitute. All those opposed, all those in favor say aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The amendment, roll call is asked on the amendment in the nature of a substitute. Clerk will call the roll.
Mr. Nadler?
Yeah. This vote will be followed immediately by, this is a vote on the nature, on the amendment nature of a substitute. The vote will be immediately followed by a vote on final passage of the bill. Do you want a roll call vote on the amendment nature of a substitute?
Mr. Chairman, we recognize for a second. I'll withdraw this. We're confused enough. Just go to A&S. I'll take the voice vote. Go to the final vote.
All those on the vote in favor of, then the amendment in the nature of a substitute is agreed to. And we will now vote on the bill, quorum being present. The question is on the motion.
One quick
the bill HR 5581 is amended favorably to the House. Those in favor respond by saying aye. Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen?
No one is.
Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. Escobar? Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Radcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Ms. Lesko? Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe?
Are there any members who wish to vote who haven't voted? Clerk will report.
Mr. Chairman, there are 18 ayes and 6 noes.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. Staff is authorized to make technical and conforming changes. I'll inform the members that there is 6 minutes left on the vote on the floor. The committee will stand in recess until immediately after the votes. We'll just wing it. The committee will come back to order. I recognize Ms. McCarcel-Powell to make a statement for the record.
Thank you, Mr. Chairman. I wasn't present for the last two votes. I would like to note for the record that had I been present, I would have voted yes on final passage of H.R. 2214 and yes on final passage of H.R. 5581. Thank you.
I recognize Ms. Escobar for a statement.
Thank you, Mr. Chairman. I, too, was not present for the last two votes, and I would like to note for the record that had I been present, I, too, would have voted yes on final passage of H.R. 2214 and yes on final passage of H.R. 5581. Thank you.
Thank you. Pursuant to notice, I now call up H.R. 5546, the Effective Assistance of Counsel in the Digital Era Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5546, to regulate monitoring of electronic communications between an incarcerated person and a Bureau of Prisons facility and that person's attorney or other legal representative, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 5546, the Effective Assistance of Counsel in the Digital Era Act, would require the Federal Bureau of Prisons to establish a system to exempt from monitoring any privileged electronic communications between incarcerated individuals and their attorneys or legal representatives. The Sixth Amendment to the United States Constitution provides the right to counsel to assist in the defense of those accused of criminal offenses. In order to represent their clients in an effective manner, the defense attorneys must have the ability to communicate candidly with their clients. The attorney-client privilege, which keeps communications between individuals and their attorneys confidential, exists in part to foster this sort of open communication. This privilege, of course, does not protect communications between a client and an attorney made in furtherance of or in order to cover up a crime or fraud, also known as the crime-fraud exemption. But to ensure free and open communication between individuals and their attorneys, a fundamental component of the effective assistance of counsel guaranteed by the Constitution, other communications between them may remain private. It goes without saying that defendants who are not in custody are less constrained in their ability to have candid conversations with their attorneys than those defendants who are in custody. Generally speaking, out-of-custody defendants can go to their attorneys' offices, speak with them freely on the phone, or write letters back and forth with their attorneys without fear of interference. To an extent, in-custody defendants also have these protections. Bureau of Prison regulations ensure that inmates are able to meet with their attorneys without auditory supervision, and that they can talk on the phone and exchange letters with their attorneys without monitoring. But these same protections need to be updated. They do not apply to email communications for the nearly 150,000 individuals currently in custody, many of whom are in pretrial detention and have not been convicted of any crime. Since 2009, email communication has been available for Bureau of Prisons inmates through a system known as TrueLinks. TrueLinks requires inmates and their contacts to consent to monitoring, however. It requires them to consent to the monitoring, even in the case of communications between inmates and their attorneys. Over a decade ago, BOP clearly recognized the growing importance of email for purposes of efficiency and speed of communication between inmates and their outside contacts. Over time, email has rapidly grown into a primary means of communication between all people, including between inmates and their attorneys. But without a system in place to maintain attorney-client privilege for emails, the Bureau of Prisons risks severely hindering the effective representation of inmates. And there is certainly no reason for the attorney-client privilege to apply to all forms of communication except emails. It is well past the time to rectify this problem. H.R. 5546 would do just that by requiring BOP to put in place a system that will exempt from monitoring any privileged electronic communications between incarcerated individuals and their attorneys or legal representatives. The bill also includes additional protections, including the requirement that the contents of electronic communications be destroyed when an inmate is released from prison, as well as authorizing the suppression of evidence obtained or derived from access to information that is in violation of the provisions set forth in this bill. This would obviously simply extend current law to email communications. This is important legislation and one that has been needed for quite some time. I am proud to be an original co-sponsor of H.R. 5546. I commend Mr. Jeffries and Ranking Member Collins for their efforts to develop this legislation. I urge all of my colleagues to join me in support of this bill today. I now recognize the distinguished ranking member, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and thank you for bringing H.R. 5546, the Effective Assistance of Counsel in the Digital Era Act, before us today. This act would help modernize our criminal justice system by extending the attorney-client privilege to electronic communications sent or received through the BOP email system, and by allowing incarcerated individuals to communicate with their attorneys efficiently and privately. Attorney-client privilege is a pivotal part of our legal system because it helps to ensure fairness. Emails between those incarcerated and their attorneys should fall under our attorney-client protections, but currently that is not the case. This bill would protect the rights of the incarcerated men and women to speak openly and honestly with their attorneys online without fear that these communications were being monitored by the prosecution. Other methods of communication, such as in-person meetings and letters, can be particularly burdensome and time-consuming, even if an attorney is in close proximity to the incarcerated client. It can take hours to travel to a detention facility and visit with the client. Time spent in transit or waiting at the prison reduces the attorney's ability to work on the client's case or other clients' cases. Telephone calls in prison can be expensive and difficult to schedule. Additionally, legal documents and other written materials cannot be shared over the phone, and postal mail can take weeks to reach inmates. H.R. 5546 requires the Attorney General to ensure that BOP's email system does not monitor electronic communications between incarcerated person and his or her attorney or agents of his or her attorney. It stipulates that these protections are limitations associated with current attorney-client privileges, including the crime fraud exemption, apply to electronic communications sent or received through the BOP system. It permits BOP to retain the contents of electronic communications until the incarcerated person is released, but specifies that the contents may only be accessed under very limited circumstances. Finally, it allows the court, upon motion of the defendant, to suppress evidence obtained or derived from access to retain contents if contents were accessed in violation of the Act. This is a good bill. It's a good bipartisan bill. Again, with my friend Hakeem Jeffries, I appreciate so much. I appreciate the chairman being a part. This is the kind of things that this committee can do well and does well together. And I appreciate that and urge my colleagues to support H.R. 5546.
Well, we're off to a good start. Are there any amendments to H.R. 5546? For what purpose does the gentleman from New York seek recognition?
I move to strike the last word.
Without objection, the gentleman is recognized.
Let me first thank the chairman for your leadership in connection with this legislation and for bringing it forward to today's markup. I also want to thank my good friend, the ranking member, lead Republican, sponsor of this bill, for his partnership on this effort, an effort that has been underway for the last several years. Today, we are here to mark up H.R. 5546, the Effective Assistance of Counsel in the Digital Era Act. This bipartisan bill will enable incarcerated individuals to communicate with their attorneys privately and efficiently by prohibiting the Bureau of Prisons from monitoring privileged electronic communications. The Sixth Amendment to the U.S. Constitution provides that in all criminal prosecutions, the accused shall, quote, have the assistance of counsel for his defense, close quote. To effectively represent a client and provide the best possible legal advice, an attorney must be fully informed about the facts of the case. But this can only be achieved through confidential communication between the attorney and their client. That's why the attorney-client privilege is so central to our system of criminal jurisprudence. There are nearly 150,000 individuals currently in the Bureau of Prisons custody, many of whom are in pre-trial detention and have not been convicted of a crime. These Americans are innocent until proven guilty. Like any person involved in a criminal proceeding, these individuals need to be able to communicate confidentially with their attorneys. While BOP regulations place protections on attorney visits, phone calls, and traditional mail, no such protections exist in the context of electronic email communications sent through the BOP's system, the Trust Fund Limited Inmate Computer System, otherwise known as TrueLinks. The TrueLinks email system has now become the easiest, fastest, and most efficient method of communication between incarcerated individuals and their attorneys. Even a brief client visit to a BOP facility can take hours out of an attorney's day when you include travel and wait times. Confidential phone calls are often subject to time limitations and usually cannot be scheduled immediately. Postal mail can take an especially long time to reach an incarcerated individual, in part because it must be inspected by staff for physical contraband. These delays should be unnecessary since the prison system for more than a decade has permitted electronic communications and would be if the attorney-client privilege were consistently applied in this instance. That is why the Effective Assistance of Counsel in Digital Era Act would clarify that protections and limitations associated with the attorney-client privilege would apply to the electronic communications at issue here. The bill would require the Attorney General to ensure that the BOP email system excludes from monitoring the contents of electronic communications between an incarcerated person and their attorney. There have been cases documented where federal judges have objected to the practice of federal prosecutors actually reviewing email communications between incarcerated individuals and their clients and using that information against the defendants. BOP will be allowed to retain the contents of electronic communications until the incarcerated person is released, but those contents would only be accessible under limited circumstances. The bill has broad bipartisan support from the American Civil Liberties Union, the American Bar Association, the Due Process Institute, the Faith and Freedom Coalition, Freedom Works, Families Against Mandatory Minimums, the Federal Defenders, the National Association of Criminal Defense Lawyers, Americans for Prosperity, Prison Fellowship, Right on Crime, and many other groups. I would like to thank them all for their tremendous advocacy. Our criminal justice system depends on the sacred nature of attorney-client privilege, and I ask all of my colleagues to support this legislation. And again, would like to thank Chairman Nadler, Ranking Member Doug Collins, as well as the Chair of the Subcommittee on Crime, Terrorism, and Homeland Security, Karen Fass, for their leadership. I yield back.
Gentleman yields back. The question occurs on the bill, a reporting quorum being present. The question is on the motion to report the bill H.R. 5546 favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 3283 to amend Title IV United States Code to permit the flag of the United States to be flown at half-staff in the event of the death of the Mayor of the District of Columbia for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3283, to amend Title IV United States Code to permit the flag of the United States to be flown at half-staff in the event of the death of the Mayor of the District of Columbia.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 3283, introduced by Congresswoman Eleanor Holmes Norton, would amend Section 7M of Title IV of the United States Code to grant the President of the United States the additional authority to order the United States flag to be flown at half-staff in the event of the death of the Mayor of the District of Columbia. Currently, under the statute, the President can order the U.S. flag to be flown at half-staff upon the deaths of principal figures of the U.S. government and governors of states, territories, and possessions as a mark of respect. This legislation would simply amend the statute to allow the President to grant the Mayor of the District of Columbia that same honor. H.R. 3283 is a straightforward measure that makes the treatment of the D.C. Mayor consistent with how the rest of the statute already treats the Mayor. For example, the governor of a state, territory, or possession and the Mayor of the District of Columbia are all provided the same authority to proclaim that the U.S. flag be flown at half-staff upon the death of a present or former official of their respective governments, a member of the armed forces from their respective jurisdictions who dies while serving in active duty, and the death of a first responder who dies while serving in the line of duty while working in their respective jurisdictions. Amending Title IV to give the Mayor of the District of Columbia equal dignity with governors and other high public officials is also consistent with the fact that the Mayor governs a city with a unique constitutional status. Unlike almost every other U.S. city, D.C.'s residents, who all pay federal taxes, are not provided equal representation before the federal government. In that respect, the Mayor of the District of Columbia is akin to the governor of a U.S. territory of possession, who would be entitled to have the flag flown at half-staff upon his or her death. At the very least, the Mayor, as the head of D.C.'s elected government, should be provided honors to those accorded a territorial governor. Regardless of whether you favor D.C. statehood, and I do very strongly, this legislation takes absolutely no position on that question, has nothing to do with it. I shouldn't have to mention this, but some people think I should. And it should be supported on its own merits. It merely harmonizes this particular section of the code with the rest of its statute, putting the D.C. mayor on par with the governor of a state territory possession. As such, I urge all of my colleagues to support this legislation. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. The flag code currently provides that the flag will be flown at half-staff 30 days, and it lists off the president, the former president, vice president, chief justice, retired chief justice, speaker, House of Representatives, and deaths on down from associate Supreme Court justice to secretaries of individual departments and vice presidents, governors of states or territories. I would oppose this. H.R. 3283 would add to this list the mayor of District of Columbia. And I think your own words sort of sum up my concern here, but it says, I oppose this legislation on the grounds that it singles out one particular mayor, the mayor of District of Columbia, and does not include the mayors of other jurisdictions. And the reason was just said by you, it puts it on par with governors, which I disagree with, and I think would
The gentleman yield?
No, because I'm not really, I'm about done, so you can have it back. If Congress is to expand the list of officials to include one mayor, why don't we include them all? I yield back.
Let me simply say that the gentleman misreads the statute. The statute does provide for the list that the gentleman read as mandatorily have staff, but the other section of the statute, which is what we're amending, gives permission to the president to fly this, permission to the president to fly the staff at half staff for mayors, governors, territorial governors, everybody except because of an anomaly, the mayor of the District of Columbia. The president can order, and all this is authorized him to do the same thing, the flag flown at half staff for the mayor of Flagstaff, Arizona, or New York City, or the territorial governor of Guam. All this does is eliminate the anomaly that the only place in the United States he has no such authority is the District of Columbia. It is not the mandatory list where he must do it, which is what the gentleman read from. I yield back. Does anyone else seek recognition? In that case, the question occurs on the bill. All in favor of reporting quorum being present. The question is on the motion to report the bill, H.R. 3283, favorably to the House. Those in favor say aye. Aye. Opposed, no. No. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up HRS 694, recognizing the importance of the Civil Rights Act of 1866 and the laws derived therefrom, for purposes of markup, and move that the committee report the resolution favorably to the House. The clerk will report the resolution.
HRS 694, recognizing the importance of the Civil Rights Act of 1866 and the laws derived therefrom.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. HRS 694, recognizing the importance of the Civil Rights Act of 1866 and the laws derived therefrom, would reaffirm the essential declaration that Congress made 153 years ago, that all persons born in the United States are citizens without regard to race, color, or previous condition of slavery or servitude, and that all citizens are afforded the same rights under the law. The Civil Rights Act of 1866 was enacted in the wake of the Civil War and passage of the 13th Amendment, which formally abolished slavery. The law was intended to protect the rights and citizenship of newly freed slaves and to unequivocally reject the Supreme Court's pre-Civil War Dred Scott decision, which denied citizenship to anyone of African descent. The 14th Amendment, which was adopted 2 years later in 1868, was intended to enshrine the 1866 Act in the Constitution so that it could never be repealed. Unfortunately, the Supreme Court, starting with the slaughterhouse cases in 1875, gutted much of the 14th Amendment and the 1866 Civil Rights Act, beginning a line of cases that still infests our jurisprudence today. An important provision of the Act of 1866, codified today as Section 1981 of Title 42, guarantees that all citizens have the right to make and enforce contracts, sue and be sued, give evidence in court, and inherit, purchase, lease, sell, hold, and convey real and personal property. The Act was a necessary step toward ensuring that African Americans would be free to develop the means to work, build wealth, vindicate their rights in court, and ultimately receive this country's founding promise of the unalienable rights of life, liberty, and the pursuit of happiness. Even though the political will to advance racial equality in the aftermath of the Civil War collapsed by 1875, the enactment of the Civil Rights Act of 1866 will forever exemplify a vital moment of political conviction and perseverance in our nation's longstanding struggle for racial equality. Although the Civil Rights Act of 1866 was initially enacted to protect newly freed slaves. Courts have interpreted the law to protect people of any race against intentional racial discrimination. At a time when civil rights are under attack in many places across the country, it is valuable to reiterate the importance of this historic statute as our country continues its fight for equality on behalf of all of its citizens. And while support for the original Civil Rights Act of 1866 was not unanimous, it would represent important and powerful progress should this resolution enjoy not only bipartisan but unanimous support today. I would like to thank Representative Waters for all of her work in introducing this resolution. I urge all of my colleagues to support it. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. I support this resolution to reaffirm Congress's commitment to the 13th, 14th, and 15th Amendment and to the Civil Rights Act of 1866 and the laws derived therefrom, and to the civil rights and liberties of all racial minorities across the country. In his I Have a Dream speech, Dr. Martin Luther King Jr. said, "In a sense, we have come to our nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men would be guaranteed the inalienable rights of life, liberty, and the pursuit of happiness. The Civil Rights Amendments to the Constitution and resulting legislation contain universal human principles that for too long applied only to some Americans and not others. For that very reason, Congress passed the civil rights legislation to fulfill the necessary obligations contained in our founding documents. Our laws must reflect a universal application of justice for everyone because justice and truth have no minority status. Justice and truth are the very bedrock of the rule of law, and if they crack in one place, they threaten cracks throughout the entire foundation. As Martin Luther King Jr. said in his letter from the Birmingham jail, injustice anywhere is a threat to justice everywhere. We are caught in the inescapable network of mutuality tied to a single garment of destiny. Whatever affects one directly affects all indirectly." I urge my colleagues to join me and the chairman in this in supporting Dr. King's principles and this legislation he supported to fulfill those principles in the resolution that is before us today. And I yield back.
Enter a statement from the bill's sponsor, Maxine Waters, into the record. A reporting quorum being present, the question is on the motion to report the resolution HRES 694 favorably to the House. Those in favor say aye.
Aye.
Aye. Opposed, no. The ayes have it. The resolution is ordered reported favorably to the House. Members will have 2 days to submit views. This concludes our business. For what purpose does the gentlelady from Pennsylvania seek recognition?
I seek indulgence to put on the record that I missed a vote on a motion earlier today. I was over in financial services, and I was opposed to that motion. I'd like the record to reflect that.
Do you identify which it was?
It was a motion, I believe, to have your words taken down.
Okay. Gentlemen, this will be reflected in the record.
Thank you.
This concludes our business for today. Thanks to all of
So,
our...
Mr. Chairman, can I have a question about that? So we're actually affirming that as an actual vote of this committee, although it was out of time?
No, she just put her comment in the record.
Which, again, for a comment for a vote that didn't really happen.
This concludes our business for today. Thanks to all of our members for attending. Without objection, the markup is adjourned.